Judge, this is Nley on page 26.
Good morning, Ms. Nunley. Ma'am, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 16th, 2025, in Harris County, Texas, an officer observed a vehicle driving over 30 miles per hour in a school zone by pacing the vehicle and officer's patrol car. The officer conducted a traffic stop. The defendant was the driver and the sole occupant and was ID'd by their Texas driver's license and AFIS fingerprints. The officer approached the vehicle and observed an odor of marijuana emitting from the vehicle. The officer discovered a backpack on the floorboard. The defendant stated the backpack belonged to her. The officer observed two small bags of a green leafy substance, one weighing 0.27 ounces and the other one weighing 0.075 ounces. The officer then located a small semi-automatic handgun in the backpack.
Nunley, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run her license, please? See if she has a valid license.
Yes.
Nunley.
Yes, you currently working on getting access to that. Very driver does himself.
Ms. Nunley, I'm going to find that there's sufficient probable cause to go forward with your case. While this case is open, I'm ordering you not to be in possession of a weapon. Do you understand? This, yes or no?
Yes, sir.
This is your bond condition. If you violate these conditions, a warrant for your arrest will be issued. You will go into custody. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, man?
Yes, sir.
Deputy Miranda can give you an application. I'll have you fill it out and I'll take a look to see whether you qualify. I need to know everything about you and then we'll take a look. If you do, we'll provide you a lawyer today. For now, I'll have you go to Victoria Center Reset and then we'll have you take a seat in the first pew back there where you fill out the application. We file conditions, no weapons, please.
Yes, Your Honor.
Isn't hearing it? Do you want to skip over that one?
Who is it? Is that the only other arraignment?
Yes, the council is not.
I get it. Who is it?
Top of page 2.
I'm going to see if I can call. That's Eddie. Okay. Yeah, we'll wait. Hi, Joe. You know? Yeah, of course.
It's the one from Monday that you emailed Chief guys on Aiden Martinez. We're trying to get a response on the mitigation, so you emailed, whoever's on
Guys,
this.
have you heard anything on Martinez?
Aiden Martinez. We submitted a mitigation packet, waiting on a response from Chief guys.
Okay.
Or PTI. Yep, there's nothing in the notes that she probably hasn't answered.
Yes.
Do you want me to stand down or do you want me to? I just.
Guys, so I guess as soon as he gets back, we'll start up.
Judge, we have one that was set for arraignment yesterday. That was with the computer, so we issued a warrant. These guys.
Okay, we can do that now. Are you, Alexis?
I have it. Is this,
Joe's? Yeah.
I'm emailing Judge guys now, Your Honor.
Do you have anywhere else to go?
Yes, I can come back, Judge.
Please.
Okay.
Thanks.
For the case number?
Yeah.
The case number is 2560085. Pipkin, come on up.
2560085.
Yes. Yes, come on up.
All right, stand right here in front. Stand by your spot.
Mr. Pipkin?
I do, sir.
So you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 14th, 2025, in Harris County, Texas, an officer viewed a theft in progress at a Walgreens store. The complaining witness advised the officer that the defendant was leaving in a motor vehicle and that he grabbed several items of merchandise and passed all points of sale without paying for them. The complaining witness showed the officer a photo of the defendant as he was walking out of the store with 2 boxes. The officer followed the motor vehicle and observed it stop at a gas station. The officer observed the defendant as the driver of the motor vehicle and recognized him from the photos shown by the complaining witness. The officer observed a passenger of the vehicle and observed the merchandise from the store on the floorboard between her legs. The Air Slim headphones that were taken were in the back seat of the motor vehicle in plain view. The complaining witness stated she observed the defendant come into the store, grab the headphones, and walk out of the store, passing all points of sale. The complaining witness stated the female individual with the defendant grabbed a basket, filled it with several items, and walked out, passing all points of sale without any attempt to pay for the items.
Wait, so she did as well?
Yes, Your Honor.
Okay, so we have a co-defendant.
Yes, Your Honor. I believe that's the case.
I heard yesterday, or the day before, maybe Monday.
Okay.
Or she was here.
So the female individual with the defendant grabbed a basket, filled it with several items, and walked out, passing all points of sale without making any attempt to pay for the items. And the complaining witness stated that in total, the female defendant walked out with $388.78 worth of merchandise. And the defendant in this case walked out with $43.28 of merchandise for a total loss of $432.04.
Sir, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walgreens. Do you understand? They have your picture there. So as soon as you walk in, you're going to have about 15 eyes looking all over you every single time you go back. Do you understand me? Do you get what I'm saying? Anytime you go there, you're going to have 15 cameras, eyes all over you. As it stands now, don't go back while this case is open. I don't want you to have contact with the complaining witness in this case. Do you understand? If I have to put you in jail, it's going to be at a high bond. No more PR bonds. You missed court yesterday. I will reinstate your bond today, but this is the last time.
Yeah, I'm on side of it. I am on side of it.
Keep taking it. Don't pick up any new cases. Do you understand? I'm not asking for much, Mr. Pipkin. I'll provide you a lawyer today. And then we'll have you talk to them here momentarily, okay? Do not leave until you sign our bond conditions. Otherwise, I will issue a warrant. You understand? Can you file those conditions, please? All right, I'm going to have you go, Deputy Miranda. We'll have you sign a reset, and then we'll have you take your seat there. Okay. Damn, he needs a coffee.
That's it. No.
Where is Ray back there?
They just walked out for it. Oh.
Receive is in the hall direction. Happy to help.
Oh, thanks, Sean. Ready?
Sir.
Okay, let's do it.
You want us here or there or?
Wherever you want. Up to you.
Judge, I need a minute.
Yes.
Um,
Yes, Judge.
sorry.
Just, sending a message to my situation.
yeah, take not too much time.
What? To go through the DMR9%. I'm just meeting with supervisors. Remember the outcome from yesterday, so they said they're not able to make them tomorrow, but they.
He gets a PR bond today.
I'll tell them.
Are you gonna do an opening?
I think I'll wait it.
You gonna wait it? Okay. So we'll bring jury in now and let's just get started, huh? You ready? Everybody ready? Okay, guys, we're going to start trial. If you need to talk, please go outside. If you need to use your phone, please go outside. No talking while we're on the record.
Judge, I'm gonna already in charge of.
Oh, yeah.
She's here somewhere with all her stuff. Yeah, sure. Inventory. I'll call them back.
Yes.
Okay.
Not yet. Let me make sure we get the interpreter first.
He's coming through.
Everybody, make sure all cell phones are off silent, all cell phones off silent.
No.
I push those to Joe's instructions to do so. This one would answer.
Victoria. Vic, did we get, what's your name? For,
No, I didn't see the sheet of it. I'm just getting your feedback.
all right, you ready? All right, bring the jury in, please. Thanks. You can bring your cell phone. We're taking no stuff. PR bond for the signature, right? Yeah, okay.
All right, for the jury.
Okay. Everyone, please be seated. Ladies and gentlemen of the jury, thank you so much for coming back. We didn't scare you off or you run away. We will try to be as efficient as possible because I know that your time is valuable. So with that, both sides will be afforded the opportunity to provide an opening. State. Floor is yours.
Morning, everybody. Thank you all so much for coming in this morning. What we have here today is a simple case.
Keep your voice up.
Thank you. What we have here today is a simple case. On October 6, 2024, Officer Metter drove here from at a traffic stop. Makes drives up, goes to the gas station, there's some signs of intoxication, and then begins an investigation. After that investigation, he concludes or he believes that the defendant is intoxicated. He takes the defendant to the station. A test is performed there, showing the defendant is intoxicated. All of this I will show to you, and after that, I will ask you to find the defendant. All I ask is that you stay with me. At the end, I promise you I will make your trial very simple. Take your mind.
Okay. Thank you, sir. Ben, would you like to?
I think so, Judge.
Okay. What's yours?
State code in this case is very simple. Officer sees car, pulls it over, sees signs of intoxication, does tests, boom, intoxicated, here we are. Right? That's what the state wants you to believe. What the state didn't tell you is what you're going to hear about why the stop happened. You're not going to hear an exact speed. You're not going to hear anything from that officer that tells you any kind of traffic violation was committed. That's what you're not going to hear. You're also not going to hear what his blood alcohol was at the time he was driving. You're not going to hear that because they don't know that. You heard it. They stop him. They take him to the station. They do a test. The test is done well after the fact while he was driving. What the state will fail to show you and cannot show you is what his blood alcohol content was at the time he was driving. Not at the time he did his test, but at the time he was driving. That's an extremely important fact for you all to remember. You're not going to hear that. Not a single state witness is going to be able to give you that fact. And at the end of it all, after you hear all the evidence, after you see everything with your own eyes, we believe that the state will fail to meet its burden and that a not guilty verdict will be rendered. Thank you.
Thank you. Vasquez. Okay. State, you want to call your first witness?
Yes, Your Honor. The state calls Officer Michael Metter to the stand.
Please.
Your Honor, the witness has not been sworn in.
Okay, sir, if you mind coming on up and raising your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Any testimony you give will be the truth.
Yes, sir.
Please take a seat. I'm going to ask you to please speak loudly, clearly. If you hear the word objection, to stop until we've addressed it, and then you may continue this, okay?
Apologize for my mistakes.
That's okay. You've got a microphone there, so if you want to bring it up close, be loud.
Thank you, Judge.
Thank you.
Judge, the mic is not on.
I'm scared to turn it on because it always goes wacko. You want to, let's see if we can go without it at first, and then if not, then I'll fidget with it. Okay, please.
Thank you, Judge. Can you please say your full name for the record?
Like already got
And what do you do for work?
Houston police officer,
How long have you been doing this?
7 years.
Can you briefly describe the training that you had for that?
It was a 6-month academy course, and an additional 6-month field training. And then after that, you have yearly training, no more mandatory.
Do you have any specialized training?
Yes, outside of the academy's SSC or standardized field sobriety, that's training. I also took the ARIDE course, which is the advanced roadside and area driving enforcement.
What did you do in that course?
That is an additional refresh course for the field sobriety tests. It also teaches a few other tests, like the Romberg balance, standard and O's, and lack of conversions. It also gives a little bit of baseline knowledge for what else can cause things such as HGN or where baseline status DL under column.
And you mentioned field sobriety tests. What are field sobriety tests?
Field sobriety tests are a set of tests by NHTSA, the National Highway Traffic Safety Administration, to establish whether or not someone is impaired while in driving.
What are those tests?
The horizontal gaze nystagmus is also known as HGN, walk and turn up or you'll often see it produced at WAT, and one leg stand or OLS.
What is the HGN that you wrote?
So horizontal gaze nystagmus is a test of a person's eyes. Gaze nystagmus is an involuntary jerk of the eye caused by depressants, inhalants, or such demands that
What are the parts of that test?
it's a series of passes for the eye. First couple of passes are testing, you're looking to see whether or not the eyes track at the same pace or if they have equal size. It's not a fluke, but it's a good baseline. The next one's a lack of smooth pursuit. This is your first actual fluke. Beyond that, the next one goes to onset, or I'm sorry, distinct and sustained nystagmus, maximum deviation, meaning you're holding the stimulus all the way out to the side, and having them focus on the stimulus for no less than 4 seconds to greater than 30. And then the last fluid is onset prior to 45 degrees. It's a way of seeing how much alcohol is in somebody's system based on how early the nystagmus sets in. There's one last set of passes for vertical. Vertical is not a fluid, but it's an indicator of how much alcohol that person's had for themselves.
And you mentioned the walk and turn test.
Yes.
What is that test?
Walk and turn, most people have seen it performed online or on TV. It's the heel to toe test, where you have somebody stand in a given position, arms to the side, right foot in front of the left touch heel to toe. You give them a series of instructions to take 9 steps down the line, a series of small steps to around and return the same line, 9 goes.
And then you mentioned one last test, the one leg stand test. What is that test?
One leg stand test is often looks like just a balance test. You have your arms down to your side, your foot up off the ground with a straight leg, you're looking at your foot and counting. Both of those tests are considered divided attention tests, so you're required to think and do it at the same time, which for a non-impaired person should be normal.
And so after you complete each of those tests, what are you able to tell at the end?
The tests aren't pass or fail, they're a collection of clues based off the clues that you get for each test. You can judge someone's impairment. Most officers are looking for alcohol. It can also be other drugs. Generally, you have other factors first.
Do you recall October 6, 2024?
Yes, sir.
Were you on shift that night?
I was.
And how did you come to be involved in the incident we are here for today?
Trying to form a traffic stop about it.
So,
Yeah, we're on it. We're getting you water now. It's okay. We got water.
Your Honor, would you like me to wait just a second for that water to come before you stop? Your Honor, may I approach? Please. I'm showing you what's been marked as State's Exhibit 1. Do you recognize this?
I do.
What is this?
This is the dash cam footage from my vehicle.
How do you notice that?
I reviewed it earlier today, signed for it.
And is it a true and accurate depiction of the events that
Yes.
Your Honor, the state would request that State's Exhibit 1 be admitted to evidence.
Just tender, please, to defense so they can take a look at it for any
Tendering state-
objections.
I'm tendering State's Exhibit 1 to defense.
I have no objection, Judge.
Okay, it'll be admitted as states one. You said that's the dash cam?
Yes, Your Honor.
Okay, did you want to go ahead and publish?
Yes, Your Honor.
Okay, please do so. Ladies and gentlemen of the jury, we have two TVs. We have this one and this one. Feel free to take a look at whichever.
All right, Officer.
Yes.
What are we seeing here?
This is the dash cam view from
I'm sorry, what was that?
the dash cam view from my police purchase.
And what is the dash cam?
It's a camera mounted inside the vehicle, tracks audio, carries to body cam, and tracks the.
I'm playing video. I am pausing the video at 10 seconds. Officer Meadow, what did we just see there?
That was a silver Malibu that passed through the intersection southwest on West Belford.
And what did you notice about that vehicle?
It appeared to be going a little fast. It's the only vehicle on the road that night. And based on the speed related with the intersection, decided to go after it. See what else. See where it's being harsh.
And what is the posted speed limit on that road? And is that road in Harris County, Texas?
Yes, it is.
I'm playing the video at 10 seconds. I'm pausing the video at 35 seconds. Officer Meta, what are you doing?
I'm trying to catch up to the people, the Malibu. The taillights that you see just under the trees are that Malibu.
I'm playing the video at 35 seconds. I'm pausing the video at 1 minute and 0 seconds. And Officer Meta, after you catch up to him, what are you doing then?
So once I get up to enough speed to catch up to him, I pace him for a brief period of time to see my travel speed versus his travel speed. So by keeping the same distance, I can judge that if I'm not gaining on him, I'm not going faster than he is. And if he's not coming back toward me, he's not slowing down.
You said pacing. You explained that a little bit, but can you generally explain what that is?
Matching solution.
And did you successfully match his speed during this?
Yes, 4 years is pretty much that second time I'm following him for probably several hundred yards of that.
And what speed was that?
You can't see on this version of the dash cam because it doesn't have the graphic view to it, but about 64 miles.
And again, what was the posted speed limit in that area?
30.
And so was that speed greater or less than 35 miles?
It is 30 miles.
And then we mentioned pacing. Was your speedometer calibrated that day correctly?
Yes, sir.
How do you know that?
The vehicle is calibrated by our fleet coordinator, and it's also calibrated with the dash cams.
Do you need a quick break, officer?
That would be better.
I'm playing the video at 1 minute and 0 seconds. I'm pausing the video at 1 minute and 22 seconds. And officer, before I say anything about this part, just want to go back briefly. You said calibrated. What does calibrated mean?
It's measured and considered accurate for the vehicle travel.
So this part of the video, officer, what are you doing here specifically?
Reading his license plate, running it on our computer. Check the registration and stuff.
And what did that check change?
This was done in October of 2024, because registration expired in November of 2020.
And so when you saw that, what did you decide to do?
Wait for the next large parking lot and pull over.
And is that what you did?
Yes.
I'm playing the video at 1 minute and 22 seconds. I'm stopping video at 1 minute and 38 seconds. All right, so officer, you, at this point, you made the traffic stop, correct?
Yes.
And where was that traffic stop made at?
Circle K over here.
Is that also in Harris County, Texas?
Yes.
And before you make that traffic stop, will we see that street? Is that a public roadway?
Yes.
So you get to the gas station and you make a traffic stop. What do you do next?
Works vehicle.
And when you approach the vehicle, who was driving it? And when you say the defendant, can you please point out for the record and identify an article of clothing that the defendant is wearing?
It was currently dressed in a gray button.
Your Honor, the state requests that the record reflect the officers identified the defendant.
Okay, it will so reflect.
So you approach the defendant's vehicle. What do you do after that?
Like on any track stop request, form of identification, inform them of the reason for the stop.
Without getting into the details of the identification, were you able to determine his name?
Yes.
And what was his name?
Of the year ago, let's say. Or like pronunciation.
Was there anyone else in you?
No one else.
So it's fair to say that he was the driver of the.
Yes.
And then what did you notice about him when you first knew?
Upon my initial interaction with him requesting information, he had droopy eyes, glossy eyes, looking over bountiful itself. Other than that, it appeared he was sleeping.
And so what did you do after that?
I requested a Spanish speaking officer.
And those things that you noticed, you said about the defendant, what were those indicative of?
Generally indicate someone's delirium. Doesn't necessarily mean intoxicated at that point, but they had at least had some form of alcohol.
And so what did you decide to do after that?
Wait for the Spanish speaking officer, connect my criminal history checks, some home, waiting to see if there's any moral return or anything like that. When the Spanish speaking officer gets there, proceed with the legal guidance.
You want to remain on approach?
Please.
I'm showing you what's marked as State's Exhibit 2, correct?
I do.
What is it?
It's not the order.
How do you know that?
I've reviewed it earlier.
And is it a true and accurate depiction of the events so reported in?
Yes.
I'm tendering State's Exhibit 2 to Defense Counsel for inspection.
May we approach, Your Honor?
Okay, so just when you get there, mute it or turn the sound down. Mhm. You redacted. So let's play this, and then in the interim, if you can get a copy, a redacted copy, we'll put that in the record. Okay. Submit that to the record. So I'll admit this, subject to well, I'll admit a redacted one into the record. We'll view this one for purposes of now, but if you can ask IT to get a redacted one ourselves. Or however. But I don't want to do redact it now because I don't want to just have it sitting waiting. Let's do it while we're on break or something. Yeah, but we'll put the redacted copy in.
And we can put that on the record outside the process of the jury. Just
Yeah. Okay. Right. You know at what time it is, right?
That's what I was talking about.
Okay. Just, do you know the timestamp?
In general.
Okay, so just let him know if you don't know that one. Perfect. Yeah, of course.
There's been published dated in the future.
Please.
And no objection, subject to.
Right, okay. So as far as my notes, I'm putting redacting.
Before I begin, officer, what are we seeing here?
The perspective from what I care, like,
And what are you and the other officers doing at this point?
we're at sea, I think it's,
I'm pausing the video at 8 seconds. I'm pausing the video at 13 seconds.
Your audio?
that's for traffic.
All right, I'm playing the recording again from 0 seconds.
So I know Mackenzie doesn't speak a whole lot of English, let him know the reason for the stop. He's traveling 64 miles an hour to 35 and registration expired November of last year.
La razón de pararnos es porque estás manejando 64 millas por hora en un lugar donde tienes que estar manejando ustedes. También tu registro sabe que haya pasado.
Sí, sí. Where's he coming from?
¿Dónde es?
De la casa. Vivo aquí sobre
¿De la casa?
sí,
¿Dónde vives? He says he's coming from home. ¿10 4? Before you hit it. Down the rest.
I'm stopping the video at 1 minute and 20 seconds. Officer, what are you doing?
Establishing some of the basic information, address and phone number, and now we're asking kind of the preliminary question, where you're coming from, where you're going, what did you do when you were there, that kind of thing.
Are you noticing anything at this time?
In this particular case, because you speak Spanish, I can't tell Spanish slurred words, anything like that, unless it's severe, so I didn't speak to that. But the more he continues to talk, the stronger the odor about all of this.
I'm playing the video at 1 minute and 20 seconds.
Entonces, apenas llegamos y repartimos lo que tenía que mudarse porque estábamos siempre tienen some clear games up in the front now. Entonces, got there was like, you say he was helping us, right?
So he's coming from Cleveland or he's coming from South?
El departamento viene de Cleveland. Ya, pero lo dejamos de Cleveland en el mejor que viene para acá porque tantísimas más para la base. Oh, so he's saying he wanted he came to Cleveland to do something at first, but he's trying out. We can't go down here because the gas is cheaper. And
Stopping the video at 2 minutes. And I'm muting the video for purposes previously discussed with council. I'm stopping the video at 2 minutes and 44 seconds. And I am going to turn back up for purposes of jury.
I'm sorry, say that again.
I'm turning the volume back on the video for the purpose of the jury being able to hear.
Belford, and the other one that gets there in West Belford to come over here.
¿Por qué pasa las dos? Oh, pero primero, no. Es que yo fui con él a dejar su esposa, entonces no viene de la casa. Oh, no, yo digo, le doy un amigo, que tenía que mudarse a mi esposa, entonces yo le digo, cuando primero le conté, le estaba preguntando de dónde venía. Oh, no, por eso le digo. Okay, so now he's saying, so now he said that he was originally coming from Sunshine, he was never coming from Long.
Okay, where does his friend live?
Con él, su amigo. O mi amigo, a mí me prima, West Belford?
Yeah, where?
So he's in his friend is where else?
I'm pausing the video at 3 minutes and 32 seconds. So, officer, we see you're asking a couple different questions here. What's kind of the purpose of this?
I'm comparing his initial statement coming from Cleveland to his now statement, I just left at my friend's house. Establishing direction of travel lies on that side of town. Because originally he stated he was on our side of town for gas from Cleveland is quite the distance.
So what does that tell you?
Inconsistencies usually mean somebody's trying to not necessarily conceal something. Sometimes it's malicious and they wish to conceal. Sometimes they're just confused or they have inaccuracies because they're not, they're not cognitively fair enough to keep a consistent statement or to verify where they're coming to from.
I'm playing the video at 3 minutes and 32 seconds.
Ahora llegan a descansar, se van a ir, están haciendo grande la persona. Oh, se están mudando ellos. Porque fue Crawford a Cleveland o de Cleveland no, de Cleveland no. Ruiz and Cleveland fue Crawford.
Okay. So he's helping them move.
Yeah.
All right, were they doing any drinking while they were moving?
Están diciendo, están hablando, no, ¿verdad?
Okay. Has he had anything to do with it?
Yeah.
¿Cómo es la salida de esa manera?
Cuando nos llevamos como temprano como a las 5, sí, no sé, la verdad, it says early 5 to 6 p.m. Yo como, no, dice Richard, bueno, de aquí también, no normal, ¿cuál es la normal? No sé, creo que es así, como media o normal. Sí, o sea, just, botella o volada. ¿Y a qué hora fue tu última bebida?
I'm pausing the video at 4 minutes and 49 seconds. So officer, the last couple of questions we saw that you just asked there, did you notice anything about those statements? Or
They're a little inconsistent. I didn't have anything to drink, and then I had something to drink at 5 or 6 p.m. And time to stop was about 2 o'clock at that point.
does that tell you anything?
Most indication, trying to conceal, if not that they had anything, just the level of which they consumed that day.
I'm playing the video at 4 minutes and 49 seconds.
Bueno, yo dice la 5, ¿y qué comió? Como flaquita, como tacos, free tacos. ¿Y a qué los tomó? ¿A qué los comer? Oh, hace un poco, una hora y media. So they ate about an hour and a half ago.
No, I thought. Has he had any surgery recently on his hands, legs, or feet?
Tengo cirugías en sus piernas, caídas, no. ¿Con tacos?
Pausing the video at 5 minutes and 26 seconds. Officer, that last question we heard that you asked, what was the purpose of that question?
It's to get an understanding whether or not somebody would have issues walking, standing, performing sort of any emotion required for the 2 SOCs that require balance.
And what was his answer to
He
that?
said no.
I'm playing the video at 5 minutes and 26 seconds.
Entonces, tiene problemas en la casa, como te ha lastimado la casa. So he hasn't had any surgeries yet, he doesn't wear glasses or contact.
Medication.
¿Toma medicamento? No medication. Hasn't had any head injuries at all.
Okay. Why did he have his driver's license yet?
¿Por qué no tiene licencia de carro?
Oh, but they.
You know, maybe we approach.
Sure.
Is this on the record?
I can't even hear you. I don't know what.
Can I just, with defense counsel?
Sure.
Redaction goes.
Another redaction?
Yeah.
Okay. So same thing. Okay, just make note of the timestamp so that later when we do, yeah, okay.
I am resuming the video without audio for the jury at 5 minutes and 46 seconds. I'm pausing the video at 6 minutes and 14 seconds. And I am playing the video with sound for the jury at 6 minutes and 14 seconds.
Presiding.
I'm trying to face them. Feet together, arms down to sides. You're gonna look at the red light. So your eyes and eyes open.
I'm pausing the video at 6 minutes and 30 seconds. Officer, can you tell me what you're doing here?
This is the beginning of the horizontal gaze seconds test. I have him trying to face away from the roadway, so there's nothing moving behind him. And he's just got a building behind that. I'm using a pin light with my finger on this. It's not too bright. And that's just so it gives him something to focus on. As opposed to saying, follow my finger, follow this into my pen. The red light makes a very apparent symbol for somebody to look at.
And we've already established he may not understand English very well. How are you communicating with him, just for the record, to ensure that he understands your instructions on this test?
The other officer, Officer Ruiz, has been translating for me. As I give the instructions, he's going to translate for him to say.
And you just said, you kind of explain how you had him turn, why you had him turn that direction, but why is that important?
Things like strobing lights or vehicles passing by can kind of trick the eyes, giving the false positive for the anti-seconds. If you're told to follow something with your eyes should be smooth, and if something then moves behind it, the natural reaction for a person is to look at that moving item and go back to the thing they're focusing on. So it'll give you a false positive, and we're looking to eliminate false positives.
I'm playing the video at 6 minutes and 30 seconds.
You're gonna fall without turning your head. Yes, sir. Yeah. What I'm going to do is see
solamente lo formo, no la canción. ¿Entendió?
Sí.
I'm pausing the video at 7 minutes and 40 seconds. Officer, you explained the HGN test in depth earlier, but just kind of refresh your memory, what are you looking for?
The first two passes, again, they're just making sure as I move on the same pace with each other, they just have different side peoples that indicate head trauma, that kind of thing. The next two passes are done the same way, from the nose out, probably the 2 seconds, and back to the other side. Instead of twice per eye, you're seeing, now you're looking for whether or not the eyes are jerking while they move, or whether it's smoothing, so that includes called lax 2%.
And are you seeing that clue here?
Yes.
And again, are we able to see that on the video? Or?
Yes.
I'm playing the video at 7 minutes and 40 seconds.
Not me, all right. We're gonna restart that one.
I'm pausing the video at 8 minutes. Officer, why did you ask him to restart that one?
He continues to look down away and then back at me instead of at the
And why is that important that you did that?
This particular clue is called distinct and sustain that sagittal maximum deviation, meaning I have to bring it all the way out to the edge of his vision and hold it for a minimum of 4 seconds. If he doesn't continue to look at it, I can't count that clue because he's not looking at the stimulus or.
And are you seeing that clue at this time?
Yes.
I'm playing video at 8 minutes.
Look at that, so I got
Cabeza recta y me hago nuevo.
I'm pausing the video at 8 minutes and 45 seconds. Officer, we just heard you correct you and say, don't look past it. What is that? What are you doing there?
When you're doing sobriety tests, you're asking somebody to look at something that's approximately 15 inches from their face. You can tell when somebody's eyes shift in their gaze and looks down the way, or it'll focus slightly out past you. So it's easy to tell when somebody's not looking at the red light that's right there.
And why is that important?
Again, by holding out maximum deviation, you're looking for that eye to jerk. If you're not at maximum deviation, and let's say they have a lower level of alcohol in your system, you're not going to see a jerk like you would on the next group that's after this one. But that would cause them to look at it and have it, but if they look down the way, it's going to stop because it's not pulling the muscle range.
I'm playing the video at 8 minutes and 45 seconds.
Oh, I got that's it. Oh, I got that's it. After research, I was trying to head.
Okay, ¿qué pasa con los chicos? Así como el
There goes. All right, two more for you.
I'm pausing the video at 2 minutes and 1 second. And so, officer, we just saw you finish that test up. What was the last part of that test?
So there are two separate passes there. The first two provide from center to about 45-degree angles, about 4 seconds. So this includes hold on to the prior 45. By moving approximately 15 inches one way or the other, and counting the seconds that you go, 1 down, 2 down, 3 down, 4 down, it gives you an approximate angle of onset. And what you're doing is you're moving slow enough to see where the next segment starts. And based on how close to the nose that is, the higher level of
And what did you see during that phase of the test?
his started at about the 3-second mark, which indicates he's going to be at or above at the type of song.
And so after you concluded the horizontal gaze and nystagmus test, what conclusions did you make?
I conclude that I had 6 of the possible 6 clues there.
And what does that tell you?
That tells me he is likely impaired on some sort of depressant, most likely.
Your Honor, may I publish State's Exhibit 1 for the jury? I'm playing what's been previously marked as State's Exhibit 1 and entered into evidence before the jury at 2 minutes and 53 seconds. And officer, what are we seeing?
This is where I'm starting next set of tests, the line turn is what we're beginning with here.
I'm playing video at 2 minutes and 53 seconds. I'm pausing the video at 3 minutes and 45 seconds. Officer, what are you doing?
So the initial setup here is the standing position. He's told to stay in the position I give him not to move until instructed. The first two available clues are somebody starting to walk too soon or not being in that position while the instructions being given. He's already broken his stance, one got back into position. Now I've just explained, I'm going to demonstrate it to him. That's the exaggerated arm slap down on the legs, is to say, when keep my arms down on my side and look at my feet, I'm going to count out loud, I'm not going to stop until I'm finished. And I've instructed him that I'm going to do 3 sets of mine, and he's going to do 9 of his.
And again, how are you communicating to him?
Officer Ruiz is standing, to the room's right.
And again, what is the walk and turn test designed to do?
So the divided attention test is to make sure that your coordination, your balance, can coincide with you processing information at the same time. So I tell you somebody to look and count at the same time, and then asking them to perform a task like walk, heel, toe. You're judging the brain's ability to split the tasks effectively, accomplish them.
And how many total clues are there?
There are 8 total clues.
I'm playing the video at 3 minutes and 45 seconds. I'm pausing the video at 4 minutes and 13 seconds. And officer, again, just to clarify, did you ask the defendant or did Officer Ruiz ask the defendant if they understood or if the defendant understood the instructions?
Yes.
And if he would have said no, what would you have done?
Re-explain in the estimate in which to have a demonstration on them.
And is it a clue if they ask to re-explain the instructions? I'm playing the video at 4 minutes and 13 seconds. I'm pausing the video at 4 minutes and 40 seconds. Officer, what clues, if any, are you seeing here?
He started before I instructed him to. That's where you see him telling him how to get back into that position before I indicated he misses all of the steps he'll fell, and he doesn't take the correct number of steps. He lands on his right foot. If you're taking an odd number of steps, knocking, your left foot should be the one that's planted as you turn around. Additionally, when he turns around, he's not taking small steps to turn around. He's pivoting his foot and facing the other direction.
I'm playing the video at 4 minutes and 40 seconds. I'm pausing the video at 5 minutes and 0 seconds. So officer, again, what clues, if any, are you seeing from that portion of the video?
In this portion, you have to go back and let them perform that turn again, so the jury can see it, but he turns and then stops prior to beginning his walking. You're not allowed to stop during the test. We're also working with relatively thin line, so we'll give some leeway in terms of stepping off the line, but as he walks back toward the vehicle, he walks at an angle and not along the same line.
And so, you previously mentioned there are 8 total possible clues.
Yes.
How many clues did you see on that test?
7, the only one he didn't do is pull his hands away from him.
And what does that indicate to you?
They're relatively high level of intoxication.
I'm playing the video at 5 minutes and 0 seconds. I'm stopping the video at 5 minutes and 25 seconds. Officer, what are you doing there?
In this particular instance, I'm explaining and demonstrating the test that you're talking.
And what test is that?
This is the one-way state.
And what kind of test is that again?
It's another divided attention test. In this particular case, it's remembering to keep your foot off the ground, but maintaining your balance while counting out loud, 1,000, 2,000, 3,000, doesn't matter if it's in English.
I'm playing the video at 5 minutes and 25 seconds. I'm pausing the video at 5 minutes and 51 seconds. And officer, just again for the record, did the defendant indicate to you that he understood the test?
Yes, sir.
I'm playing the video at 5 minutes and 51 seconds. Pausing the video at 6 minutes and 29 seconds. So officer, again for the jury, how many clues are there on the one-leg stand test?
There are 4 potential ones.
Out of those 4 potential clues, how many did you see there?
3.
What are those clues that you saw?
He used his arms for balance, but came away from his body greater than 6 inches. He put his foot down, and he also swayed and leaned one way or the other. And in this case, he kind of combined them all into one given set. He raised his arms, leaned to the side, and put his foot down, and brings his foot back up, brings his arms back out away from his body to try to balance again.
And what does that tell you?
Also indicates a higher level of intoxication.
And so after you completed all 3 of the standardized field sobriety tests, what did you conclude?
I conclude I had enough to effect arrest based on direct impulse.
And what did you do after that?
I had Officer Ruiz read the DIC 24, which is statutory warning for DWI arrest.
Judge, we're approach.
Is it the same issue as last time?
Yes, Your Honor.
Just, you know how to do it. Just keep doing it.
Thank you, Judge.
And then we'll, when we take a break, we'll.
Your Honor, may I approach? Showing you what's been marked as State's Exhibit. Can you tell me what this is?
The top copy is the GIC 25, which is a suspension of the driver's license that has to be sent to GPS. The IRS. The second page is the signed GIC 24, the statutory warning. It's in Spanish. The last one is the GIC 23, which shows the police driver observers on scene.
And what do you do with this?
That information gets sent to GPS following the arrest of the DWI.
And is this a true and correct copy of that form that you used then?
Yes.
And officer, what exactly does this form tell you? What does it do?
Kind of admit it.
Yes, Your Honor, I apologize.
Okay.
I'm tendering State's Exhibits 3 for defense counsel inspection.
Just my prior statement, Judge, which we've already addressed.
As far as redactions are concerned?
Correct.
Sure, of course. Yeah,
Okay.
absolutely. Okay. It'll be admitted, subject to the redactions.
Thank you, Your Honor.
Okay.
And also, what's the purpose of the DIC 24?
The DIC 24 is a statutory warning. It tells the defendant not what to request a sample for verbal and in most cases confirm. Then it also gives them the ability to accept or refuse and the consequences for doing so, i.e. if they refuse to provide the sample I've requested, I'll literally have to be a warrant signed for it. And that way it's said.
And how is this explained to the defendant that evening?
It has to be read verbatim off that page. So Officer Ruiz read it to him in Spanish. I requested a sample of breath, then had him accept or refuse and sign first.
And what did he decide to do?
He accepted to provide a sample of his breath and then signed voices.
What'd you do after that?
Considering down to the joint processing center, which is the jail, where we have our DWI technicians.
And when you got to jail, what you did?
You walk into the jail, you sign in, and you go to an available DWI technician, inform them which shift them is your defendant. They have a mandatory observation period they have to do. So anytime you do breath, they can't be putting things in their mouth, chewing gum, vomiting in some cases, or a high level of intoxication. And the technician sits there and watches them for that 15-minute period prior to taking them from Congress.
Based on everything that we've talked about today and your training and experience, were you able to come to a conclusion about whether or not the defendant was intoxicated?
Yes, sir, based on totality of circumstances.
And what was that?
That he was not only intoxicated, but also highly intoxicated while driving.
State that's the motion.
Okay.
Please.
Your Honor.
Yes. Floor is yours.
All right, Officer Metter.
Yes, sir.
So you just concluded your testimony by saying on your training and experience, you concluded him to be highly intoxicated, correct?
Yes, sir.
But you also indicated during your testimony that clues and field sobriety tests, and clues in the HGN and odor of alcohol, things like that, that those are generally signs that they've been drinking, but not necessarily intoxicated. Is that correct?
Intoxicated can be any alcohol or other substances.
Okay. You understand it's not illegal to have a couple of drinks and still drive, right? Now, you also indicated that in your training and experience, based on your training and experience, but you said you took the A-Ride course, correct?
Yes.
When was that?
We got 2 years ago.
Sorry?
2 years ago.
2 years ago.
Yes.
You sure about that?
I'm not positive.
Would 2021 sound about right?
It could be even after I got the position as the guy officer.
So in 2021, you took the A-Ride class, correct?
If that's the information you have, because I don't remember.
Okay. And how many hours is that course?
I think that one is 8 hours. Numerous is correct. I'll do there multiple days, but it's not 8, 16.
And since 2021, have you taken other education classes?
I've had one additional SSD refresh course since then.
Okay. What about other classes for non-DWI stuff?
Yes, every year we're required to take a minimum of 36 to 40 hours of departmental oriented, departmental,
I'm sorry, how many hours?
36 to 40.
Do you need a moment?
Not as good as they'll be. Anything department mandatory. So this would include the active shooter courses, includes penal code updates, includes any changes to legislation. That's
Okay. So this is said to have occurred in 2024, correct?
yes.
So in the 3 years that you took the A-Ride class, you only had one other class about DWI, correct?
A little bit of update course.
Okay. But you had hundreds of other hours of other types of education, correct?
Yes.
Okay. You remember taking a class in February of this year?
Not as I recall, no.
Computer operations?
Not that I recall.
February 20th, 2025, you didn't take a computer operations class?
Unless it was a video that was taken at the station, I haven't attended anything in person yet, I don't believe.
Okay. And you indicated that the field sobriety tests are designed to have divided attention, correct?
The walk and turn, the one they say, yes.
Okay. And then your testimony, you indicated, you said that is relatively easy for a non-impaired person, correct?
Those are my words.
Okay. So it's not necessarily to mean that even an unimpaired person will get it perfect, correct?
Exactly.
Okay, so even somebody who is non-impaired or highly intoxicated, as you put it, could potentially have clues on a test, right?
Yes.
Okay. And you would agree with me, may I approach, Your Honor?
Please.
You would agree with me that this is a natural standing position, correct?
It is, yeah.
Okay. This is not I can't even do it. This is not a natural standing position, is it correct?
It is not a natural standing position.
Okay. So this does require some level of balance, some level of muscle tone, things like that, correct? Okay. And you ask questions if he had any surgeries or anything like that, correct?
Yeah.
But you don't know if he'd had, maybe weak muscle tone in his legs, correct?
No way of telling.
No way of telling that, correct?
Sure.
You have no way of telling whether he had an inner ear infection or maybe some kind of balance issue or anything like that, correct?
Other than the screen question, no.
Okay. And then you would also agree with me that from this position, walking heel to toe is not natural, right? I've had a cup of coffee this morning and my hands went out, right?
Okay. That is not a natural walking position, is it?
It's not,
This is a natural walking position, right?
it is,
Even if you're walking on a line, it's still going like that, correct?
it is,
So missing heel to toe is not necessarily a sign of intoxication, correct?
but it is a clue for this.
It's a clue for the tests, right? But those tests are designed by somebody who just felt like making that test, correct?
They were designed by NISA. I would work.
You would also agree with, may I put it in now?
Please.
You would also agree with me that standing with 1 foot up also requires some kind of muscle tone, balance, things like that, correct? Okay. So again, you didn't know if he had any kind of weak muscle tone, any kind of balance issues or anything like that, correct?
He expressed to us.
I'm sorry?
Not that he expressed to us, no.
Okay, but you didn't ask him either, correct?
No, we asked him that.
Okay. Those medical screens are surgery or head injury, correct?
Yeah, anything that is likely to cause a bear.
But you would agree with me that there are other things that could potentially affect the outcome of those field sobriety tests, correct?
So, yes,
Same with the HGN, is that also correct?
there are various forms of HGN, but most are reduced or eliminated entirely, like use of stimulants. Now there's restricting on that.
I'm sorry?
Most are reduced or eliminated with use of stimulants, causing eye to focus on the thing that was just why you have somebody turn away from flashing lights or move the vehicles, because they can cause that. Rotational, if you've been spinning in circles prior to the test, could also cause distractions. And would be reduced, but not eliminated, with use of stimulants. And there
So
are
there-
medical conditions, but you know, how sure people normally tell you if you have afterwards that.
Okay, so there are medical conditions, right?
Yes,
And you said an optometrist would usually tell you, correct?
yes,
But that's not one of the questions you ask, is it?
yes, no.
Wouldn't that be important to know?
We asked whether or not he has glasses or contacts, which would indicate whether or not he's been in an optometrist.
And he didn't tell you if he had glasses or contacts,
I
correct?
didn't wear it.
But you don't know if he'd ever been to an optometrist or had his eyes checked or anything, correct? And that's not a question you normally ask, correct?
It's not.
But it's important to know.
It's important to know, yes.
Okay, so on your dash cam thing, so State's Exhibit 1. I want to backtrack all the way to the beginning. Yeah, so. Oh, sorry, may I publish on?
Yes.
Yeah. Where are you right here?
I'm northbound on Southwest.
On South Kessler?
Yes,
And what street is crossing in front of
west of.
West Duffer. Okay. Now, you would agree with me that he has a green light because you have a red light, correct?
Yes, sir.
Okay. And here you indicated that you felt he was speeding, correct?
Yes, sir.
But you don't have a side radar to be able to tell what his speed is, do you?
I do not.
Do you have a front radar to be able to tell what his speed is?
Yes,
I'm sorry?
yes,
So you're just guessing he was speeding?
based on my training experience.
All right, so about 8 seconds is when he passes you, correct?
Yes, sir.
About 9 seconds later is when you decide to pull out after him, correct?
I counted approximately 6.
So it's 17 is when you start pulling him, or 16, I'm sorry, 16. So from 8 seconds to 16, you good? From 8 seconds to 16 seconds, it's about 8 seconds, right? So he's got a little bit of a head start on you already.
Yes.
Now, we can see here that you have to make the turn when you start accelerating, correct?
Yes, sir.
So now we're at about 30 seconds, give or take,
Yes,
and about 22 seconds after he already passed you, correct?
yes.
And you're still not up to speed,
Right
right?
on.
And we saw brake lights there, correct?
Yes,
And in fact, West Belport's quite a bumpy road, right?
it is.
You can see your headlight bouncing.
Yes.
Okay, what intersection is this that you come up to here?
Well, that's Plainfield.
Move it there. Okay, so now we're about a minute, 8 seconds, minute 10 into him crossing in front of you, correct?
Yes.
So, do you know what the distance is from South Gessner to Plainfield?
Guess in Plainfield's probably 0.25 miles. About a quarter mile.
Quarter mile, right? Okay. So, if it takes you over a minute, right, to go a quarter of a mile, that means you weren't doing 64 miles an hour, correct?
I had started up to 64 miles an hour.
Okay. But it took him less than a minute or more than a minute to get there because he had a head start on you, correct?
He was already significantly further ahead. I maintain a higher speed in order to catch up to the point.
Okay, so a quarter mile, and you claim you're doing 64, but if he was doing the same speed, he would have been past that intersection before you even caught up to him, correct? At a quarter mile?
And it's a light didn't green.
Right, but you saw it turn yellow and then turn red, right?
Yes,
He didn't run the light, did he?
he did.
So you would agree with me that if his speed was the same as your speed, he would have had a much bigger distance on you and probably been through that light before it turned red, correct?
Well, he hit his brake lights twice prior to that, so his second was a bit slow also before that.
Okay, but you cannot say definitively what his speed was, is that correct?
Right, not,
You didn't have it verified by any kind of radar or any other instrument or anything like that, correct?
no, sir.
So you were just guessing what his speed was, right?
Based on speed records.
Now, you don't speak Spanish, do you?
I do not.
So you were relying on Officer Ruiz to help you with the translation, is that correct?
Yes, sir.
And you indicated during your direct testimony that he gave inconsistencies about where he was coming from. Do you
Yes,
recall that?
yes, sir.
Okay. You don't speak Spanish, correct?
No, sir.
So if we, in State's Exhibit 2, my close, Your Honor. So this is State's Exhibit 2.
35 and registration Friday, November of last year.
La razón que te paramos es porque estás manejando 64 millas por hora en un lugar donde tienes que estar manejando tu registro. También tu registro está ya por eso.
Did you notice right there when you indicated the reason for the stop, how he kind of shook his head?
No, sir. We're back home.
La razón que para mí es porque estás manejando 64 millas por hora en un lugar donde tienes que estar manejando 3.
You see how he kind of shakes his head and then gives you a look like, what are you talking about, Willis?
It looks from Officer Ruiz to myself as though he didn't do speeding, but then nods and says, yes, his registration is fine.
Okay. But registration, expired registration is not indicative of impaired driving, is that correct? And speeding by itself is not indicative of impaired driving either, is it? So in your opinion, in your training and experience based off what you just saw, do you believe that he was not challenging, but disagreeing with you on the fact that you claimed he was speeding?
At least on the phone.
And that is, the speed is a fact that you used to stop him, correct?
No, I stopped him for his registration. Just speed what caught my attention.
But you want to run his plate if you didn't think he was speeding, correct?
Why do you run any plate that's on the road?
Right, but you were going the opposite direction, so if he had just passed in front of you and you didn't think he was speeding, you would not have run his plate, correct? So the speed was a fact that you used to decide to go and run his plate?
Yes, caught my attention.
Okay.
Where's he coming from?
¿De dónde vienes?
No, de la casa, muy poquito
¿De la casa?
sí, no le veo
¿Cómo? He says he's coming from home. 10-4. ¿De a dónde vas?
No, porque es que yo estaba hablando con un amigo, pero venimos de Cleveland, entonces hasta apenas llegamos y repartimos lo que estamos viendo mudarse, porque
Okay, so there at 129, he's talking about where he was coming from, correct?
Yes, sir.
Okay. But he's saying it in Spanish, so you don't understand exactly what he's saying, correct?
Ruiz initially indicates to me they said he's coming from home, and now it's telling Ruiz where he's coming from.
Well, he actually doesn't say his home, he says a home, or a house, right, is what he says.
Right.
Okay.
He said they're coming from Cleveland. He was helping a friend out.
So there he says he was coming from Cleveland and helping a friend out, right?
Yes.
But you don't know exactly what he's saying, you're just relying on Ruiz to tell you, correct?
Yes.
Later on down the road, I'm gonna fast forward, so I stopped at about 133. Fast forward, that's too far.
He was never coming from home.
Okay.
Where's his friend live?
¿Dónde eres tu amigo?
un amigo, vive aquí en Google.
¿Cómo le llaman el friend's house? Se van ahí, estaban chutando y la corona.
Oh, se están mudando ellos. Okay.
And again, because you don't speak Spanish, you don't know what he's saying there, correct?
Yes, not until Ruiz takes his point.
Okay. So here Ruiz tells you he was helping the front move, right?
I'm sorry, what are you saying?
Sorry. Wow. That wasn't bad. That was bad. I apologize. Here he's talking about Ruiz tells you he helped a friend move, is that correct?
When Ruiz takes his point, yes.
Okay. But you don't know if that's what he said earlier in his statements, correct?
No, I have to rely on Ruiz first.
Okay, so if Ruiz didn't tell you the proper thing, you wouldn't know that, correct?
Downstairs, taking notes from seeing this would be very difficult.
Okay. And so with the fact that Ruiz was translating for you, you're relying on Ruiz to give you all that information.
Yes,
And then if Ruiz doesn't properly translate for you, then to you, that would indicate inconsistencies, correct?
it could, but that's not inconsistency, I'm afraid.
What was the inconsistency you were
He
referring
said
to?
he was driving to that side of town, so that he gasped and she learns from Cleveland.
Okay, again, you were relying on Ruiz to tell you that, correct?
Yes.
All right, so I'll reserve my questions on that for Ruiz. But again, you would rely on somebody else to tell you what he was saying and hope that they're properly translated, correct?
Yes.
In your 7-year career, am I right, 7 years?
Yes.
In your 7-year career with Houston Police Department, how many DWI stops have you made?
I don't know the exact number, more than 100.
And out of those 100 or so, how many people did you arrest for driving while intoxicated?
But without the exact number, I couldn't tell you. I know that others that didn't meet the criteria of driving while intoxicated.
And were there ever some that you arrested, but then maybe later turned out they weren't intoxicated?
I had a few that blew under the legal limit .08, and we have jail orders that prescribe what's in those situations.
So again, the clues that you observe aren't necessarily indicative of the level of intoxication. It's just based on what you think. Is that correct?
No. The number of clues specifically in HGN can indicate a higher level of intoxication based on what's there. HGN's always done in the same order because you can't have onset prior to 45 without maximum deviation. You can't have maximum deviation without maximum pursuit. They don't go out for it.
Okay, and so you previously testified, while I was asking you questions, that there are other factors that can cause nystagmus, correct?
Yeah, rotational, strobing lights, moving vehicles, that kind of thing.
Medical conditions, eyes, things like that. So the 6 of 6 is not indicative of high level of intoxication if there are other factors present, correct?
Without other clues.
And then those other clues were,
What's the totality of circumstances?
the walk and turn, correct?
Well, other clues in the sense that there are other tests, yes, but other clues in the sense that what you smell on scene, what you see in the eyes, response, movements, that kind of stuff.
Okay, but you would agree with me that alcohol actually does not have a smell, correct?
Different types of alcohol have different smells. You can tell the difference between a spirit and a beer. Most people know the difference between say, whiskey and Bud Light.
But you couldn't tell what, if anything, he had to drink, correct?
It smelled like beer. I couldn't tell you what brand of beer.
And again, not illegal to have some fajitas, as he indicated, and drink a beer with that, correct?
It's not.
And even if 1, maybe 2 beers, though maybe not intoxicated, it would still have that odor, correct?
Yes. And that's what the test is designed to screen.
Within the tests, which are fundamentally flawed, correct?
No, sir. It's done quite a bit of research around cicadas.
So again, may I approach you, Honor? Please. This is what NHTSA says is appropriate to do for a test, correct?
Instructions.
Right. And then you said he started before you told him to, correct?
Yes.
Isn't it possible that some people sometimes are eager to just get the test over and done with so they can go home?
That's possible.
Okay. So not necessarily a sign of intoxication, correct?
As an individual clue.
Okay. And again, not hitting heel to toe, this is not a natural walking position, correct?
Correct.
So not necessarily a sign of intoxication,
As
correct?
an individual clue now.
Okay. Wrong number of steps. You said he took too many steps.
He took a few steps. He took 8 steps instead of 9.
Okay. And then you said he made the wrong turn. How many times do you demonstrate the wrong turn or the turn?
I demonstrated immediately before they did the test themselves.
Okay. But that's still, they still have to take 9 steps before they make that turn, correct?
Yes.
Okay. So you said small steps, didn't do the small steps to turn around. Again, when somebody turns around when they're walking, when they turn around, this is a more natural movement, correct?
It is.
Not this, like a penguin?
It is.
Okay. Now, he didn't fall over, correct? He didn't use his arms for balance, correct?
Not on that test, no.
He wasn't stumbling, he wasn't tripping over anything, nothing like that, correct?
Not on that test.
The only clues that you saw were clues that are just unnatural human movements, correct?
But no, so I saw the clues that I described in the test for him.
Right, which is
He was
not heel to toe.
He was instructed to take 9 heel toe steps. He did not. He was to turn around in a specific way. He did not.
Okay. But again, those are not natural movements, correct?
But they are instructions.
I get that they're in the instructions. I'm asking if they're natural movements. How many times have you done the field sobriety test?
Every time I've done any sort of arrest.
Okay, so every time you've done an arrest for a DWI, you've done hundreds of DWI arrests, you've done this test 100 and something times, correct? Plus the times that you did it when you were there,
Yes.
correct? So you don't know, I mean, it's not like a person sits at home and says, I'm going to practice the field sobriety test and learn how to do it and make sure I have it memorized, correct?
Correct.
They hear it one time from you and you didn't even relay the instructions in Spanish, correct?
I did not.
And you hope that the instructions were relayed appropriately, correct?
Yes.
And then that one time, that 5-10 seconds that you show it to them, you expect them to remember it while they're in the presence of police officers with flashing lights behind them in a stressful situation and do unnatural movements. That's what you're saying you expect them to do?
I expect him to perform the test yet.
Okay. And I'll pass the witness straight.
Okay. State, you have any follow-up?
Yes, Your Honor. Officer, how many people have you pulled over for speeding in your career?
I couldn't tell you.
Could you give an approximate number of how many you pull over per week?
No.
Could you,
So let's not fishing expedition. Keep it nice, keep it neat.
is it fair to say that you pull over a lot of people for speeding?
A fair amount, sure.
So again, what initially drew your attention to the defendant's vehicle?
I'm familiar with that intersection. Our station is less than a mile south of that. So you get a general sense of low traffic. And when somebody passes in front of you, that's that expectation of generally indications.
Now, at that point, did you make the decision to effect a traffic stop?
Yes.
Okay. So What did you do after that?
I caught up to the VU, and when he stopped at the light, I ran his plate to see if there was anything else I could want.
And when did you decide to effect the traffic stop?
After finding his registration expired.
Did you decide to do that at any point before you found the registration was expired?
This,
Now, let's go back to the standardized adult sobriety test we talked about. Was the HGN the sole reason you determined he was intoxicated?
it was not.
Was the walk and turn the sole reason you determined he was
It
intoxicated?
was not.
Was the one leg stand the sole reason that you chose? What were the reasons and what facts led to your determination that the defendant was intoxicated?
Such as how they all was presented within the field sobriety tests in addition to the odor of alcohol, the glossiness of his eyes.
Now, let's talk a little bit more about the field sobriety test. Are they supposed to, specifically the walk and turn and the one leg stand, are they supposed to be natural movements?
They're not.
Why?
Because natural movements wouldn't give you an indication of someone's balance or ability to pay attention.
And are these certified tests?
They are certified tests.
And who certifies those?
National Highway Traffic Safety Fleischer,
Are they widely used?
everywhere in the United States.
And per the translation from Officer Ruiz, did you have any indication whatsoever from the defendant that he could not complete the test as instructed?
Yes.
And you said it before, but what happens if the defendant indicates to you that he doesn't understand the test?
I'll re-explain everything.
Do you hold it against him? Does it count as a clue?
No.
Was he free to ask for a re-demonstration of the test?
Absolutely.
Did he ask for that?
He did not.
And so, officer, let me just touch on this just a little bit more. If you didn't have the inconsistent statements from the defendant, per the translation from Officer Ruiz, would you still continue your investigation?
Yes.
Why?
Because of the odor of alcohol.
State passes the witness, Sean.
All right,
Briefly, Your Honor.
please.
So just based on the odor of alcohol, you would continue your investigation, correct?
Yes.
But again, 1-2 beers, you're gonna have an odor of alcohol, correct?
Yes.
And as far as the glassy eyes are concerned, and again, not illegal to have 1 or 2 beers and drive, correct?
Correct.
As far as the glassy eye is concerned, he told you that he was coming from Cleveland to help a friend move, correct?
He did.
So is it possible that he could have been up for several hours prior to getting pulled over by you?
Objection, Your Honor. Speculation.
I'll rephrase it, Judge.
Okay.
So you indicated in your body camera that Cleveland was quite a distance away, correct?
Yes.
Okay.
So probably an hour or 2, maybe, to Cleveland?
I haven't driven there recently, so I can tell you.
And then based off of that, driving from Cleveland, helping a friend move, does it make sense that, or would you have reason to disagree with me that he could have been up for several hours at that point?
Objection again, Your Honor. Cause for speculation.
Answer, if he knows.
Without him specifying how long you've been waiting, I have no idea.
But you didn't ask that question, did you?
Does
So if somebody had been away for several hours, they could have glossy eyes, correct?
they could
So again, not necessarily a sign of intoxication, right?
buy it something that
And then the state followed up by saying, asking you about the speeding, but you testified earlier that you could not tell exactly how fast he was going, correct?
I did not.
So you have no idea whether he was speeding or not?
You can go generally past from that intersection only. Yes.
Okay. And you said you're familiar with that intersection and you can tell how fast somebody's going, or you can generally gauge how fast somebody's going by the flow of traffic, correct?
Yes.
How many other cars were on the road?
No other cars.
So there was no flow of traffic to be able to tell, correct?
But that doesn't change the fact that I've been through that intersection.
Okay. That wasn't my question, sir. My question was, there was no flow of traffic, correct?
No flow of traffic.
And so with no flow of traffic, you have no other vehicles to gauge your perception on, is that correct?
That's not known.
So, and again, just to make sure I'm clear, you testified earlier that what drew your attention to him was what you perceived to be speeding, correct?
Yes, sir.
And then when you catch up to him, you run his plate, and then that's when you find the expired registration, correct?
Yes, sir.
And then based on the expired registration is why you decided to pull him over, correct?
Yes, sir.
And then when you told him he was speeding, he seemed to question your speeding, your perception of speeding, correct?
That's correct.
So would it be fair to say that he was challenging, not necessarily challenging, but disagreeing with what the reason was why you stopped him?
He may have been from speeding.
Okay. And the speeding is a fact that you used to run his plate to pull him over, correct?
It's what our initials and
Nothing further, Judge.
Okay. All right. May this witness be excused.
I would like subject to recall, Judge.
Okay, officer, if you don't mind, you're done for now. If you don't mind, just taking a seat in one of the witness rooms and do not leave just yet, please. Go. Let's take a break. Okay. All right, ladies and gentlemen of the jury, we're going to take a brief recess, give you time to handle any matters you may need to handle. We need to handle little business matters as well. I'll try to bring you back as quick as possible so we can continue, okay? Please, you go with Deputy Miranda. Off the record. Okay, everybody, thank you for patiently waiting. I know you guys want to go. Let's go. Come on. Hi, Cena. What you got, bud?
Hello, how's the meeting in your case? It's a reckless driving case.
Okay.
Discussing it, she's been in trial, so
Have we done PC yet?
no, it's very new case. Okay.
Let me split.
Yeah.
Oh.
After 262nd, I'll be right back.
Say it again?
After up to 262nd, I'll be right back.
Jason, what was last?
Alzabine, A-L-Z-B.
I got it. Okay.
Z-A.
You do work with Eddie, right? Okay. Mr. Albazin, come up.
Judge, can we send you so that when back?
He's got 4 total.
Good morning, sir. You speak English? Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Thank you, Your Honor. On April 10th, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling at a high rate of speed, failed to signal a lane change, weaving in between cars, and following too closely behind other vehicles. The law enforcement officer matched the defendant's vehicle at approximately 100 miles per hour. A traffic stop was conducted, and the law enforcement officer made contact with the defendant, who stated he did not know he was going that fast.
Okay.
And, if I could, Your Honor, just real quick, basically, we had an opportunity to look at the videos. My client has a radar chip in his car. We've shown it in the state. His car wasn't going over 90 miles an hour, and he clearly using his indicators. And on the video, the officer says that he doesn't know how fast he was going. His car has no radar, but he thinks it's 90 to 100 miles an hour.
I mean, you're going through video. This is just probable cause hearing. We could set it for something, but
There is no actual speed that he paced my client. So there is, just to let you know,
speeding in and out of traffic, falling too closely.
according to the officer, right?
So I'm going to find probable cause for
That's
now.
fine.
We can always set it for, because I have to give them the
No,
opportunity.
absolutely, Your Honor, absolutely. I
So-
think the chief, once he's, done with this trial, he's already told me it's going to be either a class dismissal or straight up dismissal.
Sir Albazen, I'm going to find probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive in this manner again. If I find that you drive at speeds of 90 to 100 miles an hour, doing reckless driving, weaving, I'm speeding, I'm going to revoke your bond and put you in jail. Just, we have enough crashes on the road. Don't add to it. You know what I mean? No reckless driving, racing, street takeovers, donuts, nothing of this matter. Got a great lawyer. He's going to help you out. Stay in touch with him. We'll give you guys time to work on the case. I'm going to have bond conditions created so you promise us that you're not going to drive like this. If I find that you do, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
Okay, so we'll have you sign a reset. Just have him take a seat. We'll get bond condition created, and then once you sign it, at that point, you can leave. Leave. Can you file that, guys, please?
Yes, Your Honor, what are the conditions?
So no racing, reckless driving, street takeovers, donuts.
Yes, Your Honor.
Okay, Mr. Beadle. So I signed the jail release conditions. We'll do a PR bond now, so that way she's good to go.
Need to bring her out.
No, I don't think so. No, I think you're good to go. You just make sure that, don't send her down until she sends a PR bond, and then, yeah, she's here. We got her.
She's going to be the chair on this lunch.
Yes. So, Ms. Roxanne, do you mind giving Ms. Lynch a PR bond, please? Okay. And then as soon as it's processed, we'll have her sign it, and then she's good to go.
She's gonna sign it, or we're gonna bring her out?
Well, yeah, we'll have to bring her so she can sign it. That's why we put her on, so that she can sign. Yeah. Okay, hi.
Good morning, Judge. I have Ms. Nabila on docket.
Okay.
She was accepted into the PTI program, but we're trying to knock out some kinks with a no driving affidavit. I was wondering if we could amend her bond conditions to give her portable and have the county pay for it before she goes into the program.
Can't pay for it when she's in the program.
Before then?
She's on bond, I can, but once she signs into the contract and gets into the program, I cannot pay for it any longer. I pay for virtually everything for as long as I can, but once they're in it, or on a probation or on a PTI, I no longer have the authority to pay for it. If I could, I would, but I just can't. So she'll have to sign a no driving affidavit, and you can get one from Shatoria. Then once she gets the portable device, at that point, we can take off any guardian interlocks or anything else that she has. Yeah? And then, what about the DA fee? Has she paid it yet?
So we haven't yet. So we just put out her form. We got accepted on Monday. So we just got her form. She filled out her form, and then they
Which form for which one?
the client intake information form.
Got it?
Yeah, so we just got that on Monday. She filled that out today. And then the no driving, she emailed me that her driver's license was ineligible on Monday as well. And so
Okay.
no driving affidavit.
Okay, so how long do you want? Done. Yeah, okay.
Thank you.
Yes, ma'am. Hi, Joe.
Just coming back on Mr. Martinez,
Nice.
That works.
Sorry?
Tell me something nice.
no response yet, Judge. Like I said, I have some from January that I still haven't received responses, so March. Can we get like a week reset, Judge? Okay, all right, thank you. Parents, wait. Okay, thank you.
Unless there's approval or denial at that point. Yes. Okay, thanks, Jim. Shreya. Hi, good morning.
Justin Harris on the fugitive docket.
Justin Harris?
I know. I kind of laughed. Yeah.
I'm just kidding. I'm just kidding.
It's funny, 'cause I just seen him yesterday. Justin Harris is on the fugitive docket. He waived at the magistrate court and has vehemently changed his mind.
Should we? You're laughing. Do you want me to bring him out?
So Judge, if you want to bring him out and admonish him, Philadelphia, from what I hear, does want him. Is that right, Amy?
Yes, we're on their way here to get him today, but if he's withdrawn his waiver, of course they can. If he intends to withdraw his waiver today, they obviously can't pick him up today, so.
If they're gonna get him, they're gonna, hey, Deputy, you mind bringing out Justin Harris, please?
And then while he's coming out, do you want me to reset the Dustin Eli hearing?
Have they done anything upstairs? It's on docket today?
No, they haven't. So I was going to talk to you about that. If he takes TDC up there, would you consider?
If he takes TDC, there's nothing I can do.
I agree. And that's, I mean, and I hate to say that because I don't know what they're doing, but if we could
Obviously, if
reset
he
it, I think it's an option.
No. If
Okay.
it takes TDC time,
Okay. And I hate to say that because I don't know what'll happen in May,
no-
but I think it could be worked out. Yes, Judge. Your other option was to put him into state of.
No. My feeling is that he's probably gonna end probation, right?
No.
Really? Have they not offered probation upstairs?
They might, considering the nature of it. If they do, they're going to require state of, right?
I mean,
Right. And that's the end goal is I don't think he wants that.
he's willing to go to TDC instead of going to treatment, for real?
Yes, I know.
Well, I mean,
I've talked to him. I know, and I'm going to set up another meeting with him to go over things, but
be the horse to water.
there's only so much I can
I know.
admonish.
Yeah, so
They just.
that case is set for May 12th,
So
I guess.
if I can just get like a day or two after that.
Absolutely. Good morning, Mr. Harris. Good morning. So you're wanted out of another state. You already waived, and your lawyers tell me now that you would like me to set you a bond so that you can go out and go turn yourself in.
Oh, no bond. I just wanted him admonished on the extradition timeline.
Okay, so you've waived. What happens is we give the demanding jurisdiction, which is who?
Philadelphia County, Pennsylvania.
Okay, what's he wanted for?
Murder, endangering welfare, and
Okay, yeah. So you're wanted for murder and what else?
endangering welfare, and then they're charged that's REAP.
Well, they,
Rape?
It's they spelled it REAP.
ain't no damn rape. I ain't raped nobody.
I don't know exactly what that one is, but for sure.
So understand that we just get the teletype that tells us what it is. I have no idea. Here, we don't fight the case. We only try to establish identity. If you are the person that is wanted from the other jurisdiction, I don't know. The good news is though, is that you've waived and they're coming to get you today. So we could really get you on the way back to Philadelphia today.
No, I said I'd rather put the 30 days in. Didn't I tell you that?
You did, but I'm just admonishing you. It's not just 30 days. It's
So
30
what
days.
happens now is,
I just want to make sure you understand that.
so what happens now is if you refuse, which is your right, they'll get a governor's warrant, but that'll take up to 90 days to get,
I'm
you
fine
know?
with that.
And then the pickup is 30 days after that, just to make
Okay,
sure we're good
I'm
with
fine with
timelines.
that. I'm fine with that. Cause I'm
Right,
trying
so-
to get everything in order back to there. I'm not about to broad rush, be blind, go back to Philadelphia. And then I don't know what's going on inside my county, like as far as being held inside, like it just.
You want it from other counties as well?
I have no knowledge of that at this time, Your Honor. I would have to run a criminal history check if I could get one of the processes.
So I guess you just want them to get a governor's warrant, then I'm assuming you did. Okay, so if you just want to go ahead and,
I've got it by them.
And then Judge, the waiver withdrawal should be in your queue.
Yes, it's right. Okay, I'll sign it and then, all right. So I guess let's set it for 45 days. What do you think?
I have him set out for 30 days.
Okay, not a problem.
So it's going to be May 23rd.
Okay, so the problem is you have to understand also is that when someone is charged with a crime that has a potential life sentence, I can't give you a bond even if I wanted to. Just that's the way the statute reads. So, okay. All right. Good luck to you, Mr. Harris.
Thank you.
Thanks, Judge. Thank you.
Thanks. Hi. Mr. Davidson, did you? Hi, how are you? Pretty good.
I'm just here to take care of business. I don't have anything.
You know nothing? Okay.
Nothing for the court at the moment.
Greg? Nothing. Hey, don't go far. We're going to start up soon.
We need to approach before we do.
Okay.
Before we bring Jerry back out, let's have a few matters I want to bring up.
Okay. I think that Blaze went up to the felony court regardless, so.
All right.
Blaze went up to one of the felony courts, so I don't know when he's going to come back.
Does we have an arraignment? Are you ready?
Yeah.
All right, page 5, bias, come on up.
Hey, where's the other prosecutor? Where's John?
Get you?
Yes.
Where's John, the other prosecutor? Do you know? Hey, Cole, can I borrow you real quick so we can do PC real quick?
Yes, Your Honor, of course. My apologies.
This is Mr. Bias. B-A. All right, Mr. Bias, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Can you, I get the name one more time, please?
Let me give you a cause number.
Yes, Your
Tell me when you're ready. 256
256
0257.
2257. All right, thank you, Your Honor. On April 15th, 2025, in Harris County, Texas, an officer observed a motor vehicle traveling on the Gulf Freeway. The officer visually estimated the motor vehicle speed to be between 115 and 120 miles per hour in a 60 mile per hour zone. The officer attempted to catch up to the vehicle and observed approximately 15 to 20 lane changes from across all 4 lanes of traffic around other cars that were obeying traffic laws. The officer had to travel at speeds in excess of 120 miles per hour to catch up to the defendant's motor vehicle. Officer caught up to the motor vehicle and paced it at 115 miles per hour for approximately 1/4 mile. A traffic stop was conducted and the defendant stated, "I effed up."
Run his license, please.
Yes, Your Honor.
Mr. Bias, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive in this manner anymore. If I find that you're a danger to my public, it's not going to go well for you. Do you understand?
Yes, sir.
I will revoke your bond, put you in jail, and no more PR bonds.
Yes, sir. The license is open.
You are not allowed to drive unless you have valid Texas driver license and liability insurance in your name, and that is a condition of your bond. If I find that you do, or that you drive without, likewise, you will go to jail. No more PR bonds.
Yes, sir.
We are going to reset your case to give you time to hire a lawyer. I'm going to have the state create bond conditions that you're not to drive in a reckless manner. You're not to participate in a racing street takeover, donuts, anything of this nature. I will do everything in my power to protect my city at all costs, Mr. Vice, and I want you to understand that. And if I find any more of this, it's not going to go well for you. Do you understand?
Yes, sir.
Do you mind filing those conditions, Cole?
Yes, Your Honor.
For now, I'm going to have you sign a reset with Victoria. We will have you take a seat while we get your bond conditions. Once you have signed them, then you'll be free to go. Please.
But,
Yeah. Hi.
I had a quick question regarding off docket.
Okay.
2521794. The name is Crystal Gonzalez.
Okay.
She's scheduled, her case is old, and she's required to appear tomorrow. You said she would have to appear if everything isn't done for PTI. We have her contract back. I talked to Ms. Gomez, she's the PTI coordinator. She said that the only thing she needed was the contract and proof of the device. Well, we have her contract back. And she also attempted to get the portable device, but they don't have it coming in until the 28th, which is Monday. And I have a copy of her contract for the portable device. Will she still need to be present on tomorrow?
Have proof that the device is coming in on the 28th?
Yes, sir.
Okay, no, I trust you. As long as you have it, then we'll set for the 28th.
Okay.
Okay, and she has to have everything done by then.
Yes, sir.
Okay, no more waived appearances.
Yes, sir.
Okay.
Thank you.
Yes, ma'am.
Yeah.
Hi, Sarah. You ready?
I'm not approaching.
No, oh, no. Okay.
I'm
Come on
sorry.
in. That's okay. Hi.
Yes, we have Edelbert Rosas on docket, ROS.
Okay.
We still do not have a response on the mitigation packet. We emailed them this morning and there's an email saying it might still be under review. We submitted it 4/7.
Okay, so we'll set you off.
Comments.
Set you off 1 week for them to get you their fine.
Will my client need to appear or can he be waived?
If it's not back, then no, but if it's back, he's got to get everything done. No more waived. It's 230 days. No more waived appearance. Okay. Okay, hi. Come on up. Yes, sir.
This is an off-docket case, Judge.
Okay, what's your cause number?
255-8479.
On Billings.
Yes, Judge.
Okay.
He is present here in the courtroom. Police made contact, did not arrest him until the blood test came back. The warrants have now been issued, so we're here to address that.
Can I bring him on?
Yes.
You get the cause number?
Yes, sir.
Go ahead. Hey, this is a new case.
Sorry.
4/17/26.
This is a new case. 8479. You are Mr. Billings?
Yes, Your Honor.
Mr. Billings, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine because of the high level of alcohol. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay, cool.
Thank you very It's not loading for me, just 1 second.
I've already computed some.
Roxanne, did you get this cost number? I need to give it to you. It's a new case. 255-8479.
Thank you, Judge.
Sure. Let's go.
On December 7th, 2024, in Harris County, Texas, officers responded to a motor vehicle accident. The officer arrived and observed 2 vehicles that had been damaged and rendered inoperable. The defendant was ID'd by his Texas driver's license and ID'd to be the sole occupant and driver of the motor vehicle. The officer relocated the scene to a nearby parking lot to safely conduct the investigation. The officer determined the defendant was at fault for the accident after speaking with all the parties involved and reviewing information collected at the scene. The defendant stated he had left a bar called Sugar Room. The defendant stated he drank 2 beers at the bar. The officer noted that initially the defendant was not even aware that he had been in an accident. The officer observed the defendant to be lethargic and confused. The officer observed the defendant to have slurred speech, glossy eyes, and trouble maintaining their balance. The officer had to ask questions multiple times to obtain simple information from the defendant. The officer did not notice alcohol emitting from the defendant despite defendant's admission to drinking and defendant's apparent physical and mental impairment. The officer suspected the apparent impairment of the defendant could have been caused by some kind of narcotic. The defendant refused to perform standard field sobriety tests. The DIC was read. The defendant agreed to provide a blood specimen, and the lab results came back to a 0.17.
Okay. Any prior DWIs? And does he have
the first
and valid license?
Judge's license was recently suspended ALR. He will not be driving. He has a 90-day suspension.
Okay. I want you to understand something, Mr. Billing. I take this extremely serious. I don't care what you have to do in your life. If you do not have a valid license and liability insurance, you are not allowed to drive, and that is a condition of your bond. You will be signing an affidavit with me today promising me you're not going to drive. I don't care if there's a burning building and you have to say 50 kids. Do not drive. Do you understand?
Yes, Your Honor.
Nothing you can say justifies getting into a car and driving. I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you do, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you if and when you have to come back to court. If you get called upon to go take a test and you fail to go, a warrant will be issued for your arrest. Do you understand?
Yes, Your Honor.
Okay. But now I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Victoria where you'll sign a reset. After that, you'll get to Roxanne where you will get your bond conditions, and then you're free to go.
Thank you, Judge.
Yes, sir. Okay, counsel.
Morning, Judge. How are you, sir?
Howdy. Been a while.
Yes, sir. I'm doing well. I'm here on Matthew Owen this morning. I'm here for Mr. Pulowski. He's across the hall doing a plea. It's been my understanding that he has been accepted into PTI. He's done his TRAS. We've gotten the TRAS back. We're just waiting on the contract from the DA's office.
Cole, what say you on Mr. Owen?
I do have a note here. We have the TRAS saved, and I have a note from today at 9:02 a.m. that it says DWI PTI insurance expires 9/18/25. I'm not sure if that's the valid insurance that he had to submit or something.
I believe it would be.
Okay, and then that's the latest I have on that, so I guess we haven't gotten a contract.
You're not going to get it, I guess, until they give you get insurance.
That's what it sounded like.
So we'll set you off for a week. Okay?
Yes, sir.
It's getting old. It's 190, so no more waived appearances. If you get everything done, then I'll waive it, but if not, he's got to be here.
Absolutely. Yes, sir. Thank you.
Thanks, man.
Isn't Bond on him, or is it?
Oh, I don't know. Wait a second. Bond? Is he on bond? Did he make a bond?
No, Judge, we're asking for a PR bond. I thought you said you granted him a PR bond.
No, we haven't. I assumed that, no, I haven't given PR bond.
Yes, we're asking for the PR bond. He was not arrested.
Okay, come up, Mr. Billing. I didn't realize that. Thank you for saying something. All right, Mr. Billings, I'm going to give you a PR bond today. There's a warrant for your arrest, so I'll give you a PR bond today, but I want you to understand, I don't continue to give PR bonds after PR bonds, especially if you're a danger to my city. I'm going to give you one now, but there won't be multiple ones. You understand? Okay, all right, you're done. Thanks.
All right, so just have a seat and please follow the motion.
Thank you.
Hey, Jay, what's up, man?
I wanted to reapproach on Justin Harris. I know I just missed it by a hair. I was upstairs in another hearing and I wish I knew about it.
No, I've never refused or denied a waiver withdrawal.
Because it's in your power to do so, and obviously you haven't seen.
And are they still coming here today?
They're here right now.
But then I'm not gonna grant this waiver withdrawal. Let them know. They're here from.
I can't let them know. Well, okay, I'd love to let them know.
They send them down already?
Is there any reversal?
Is there a way to communicate to where he's going?
We're going back to jail, so he's already in time to go ahead to jail, so that they know he gets back.
Okay, so let's do this. I'll reach out to my court manager to try to tell admin to let them know.
It's like dumping, and I'll let his family members know, but I don't mind even going to the jail, but I think that I won't do it.
No, I'll call my admin right now.
Sylvia?
She can get it. Yeah, she's
magic.
adult.
She's
So-
magic. Do you want me to wait, see if he gets brought up, or y'all can?
No, we're not gonna get him back up.
Just pass the
They're saying
message.
he's in transit back and then which is good because that way they can get him to Pennsylvania.
Right,
Let
and
me
I
just
just
step
want to make
out.
sure, it's e-filed, so I don't know what you do electronically, but.
I can unsign it.
Okay.
Okay, that's not a problem.
Okay, thanks.
Reach out.
Thank you, Judge.
Wait a second. What was the name?
Harris,
Justin Harris. It's Justin's
Okay.
face.
Justin's in jail.
Yes.
Damn.
They really wanted me to.
It's one of those things.
Hey.
Now, before we do, pending, or would it like Okay, there's 1 week. 5/7.
Reach out.
Stacy. Hi.
I have Mr. Demikia, the custody case.
Okay.
And Your Honor, he has 2 DWIs. I was speaking to the state regarding an offer for a time served on one and dismissal on the other.
Okay.
We were just wondering if you would accept that offer.
Yeah, I mean, I'd be hard pressed to do a time served, but,
He's been in
yes.
custody for 21 days, has an ICE for previous deportation. No videos on one of the cases that I'm requesting get dismissed. They're not gonna get it.
Okay, yeah. We do like, I don't know. So he has how much?
I believe
25 days.
So do 60 credit for 25 and on whichever one, and then,
on the one with the
Well, yeah, I
videos.
think we were at 75, just to keep it
oh, yeah, whatever you want. Yeah.
That works with
Yeah. Okay. And then are you guys ready to?
We're working on that redaction issue right now. So,
He said he wanted to approach on something too.
yeah, this was, yeah, completely, yeah.
I don't know if you want this on the record, but I've thought about it. I don't think I'll need Metter again because he didn't say the inconsistent statements were a major player. So that's really I was going to
That's
focus
something.
on.
No, so let's just let him know. So, I mean, he felt awful. Let's just get him out of here,
Yeah, and that he's got to work tonight too. So
Gosh.
yeah, so I'd rather just get him out of here.
That's good. Do we want to put that on the record?
Okay, quiet, we're going on the record. Please do not say anything. All right, we are back on the record in the trial case. And after speaking to both state and defense, both of you guys have come to the agreement that you are ready to release Deputy Metter not subject to recall anymore.
Your Honor. That's correct, Your Honor.
Okay. All right. So we'll let him go.
Thank you, Your Honor.
I guess we'll start here momentarily.
Okay. Thank you, Your Honor.
Thanks.
Page 4.
Hey, hi, Matt. Come on up. How are you?
Good, you?
Good job,
Don't know what to do about Mr. Burnett, or Mr. Bennett. I know that you said he had a prescription.
He does.
Right? But that prescription was from, what, 6 months ago or something?
I think he has he has numerous valid prescriptions. Do you not? Can I bring him up here and talk to him?
Yeah, but he does. Otherwise, I don't want him to use, you know? I mean.
I get that. That's where, and as a lawyer, it's hard for me to sit here and tell him like, hey, don't listen to, if the doctor's, again, I get the look and feel for these types of prescription, just give them, there's tons of pill mills in the city. I get that stance, but then it's also hard for me to say as a lawyer, well, how do I say that this guy needs it and this guy doesn't when I'm not a doctor? And so it's hard for me to tell him, hey, don't do what the doctor says when
When did we do our first?
I feel like I've been here once a week, every week for the last 3 weeks on him.
That's what
I mean, it's fine. Yeah, I get it.
No, I mean, that's why they're so difficult.
And it's not, I'm not upset by that or anything, but.
Here's what I want to know. I want to know when it's going to stop. He's got a prescription. If I remember, it was for 90, right?
This probably sounds right. Yes, Your Honor.
So I want to know when it's going to stop because I'm not going to let it continue for the next 6 months. You've got 90. You're not going to sit here and tell me that 90 is going to last you for the next 6 months and that you're going to continue to use. It's not going to happen. Come up, Mr. Bennett. And what's the purpose for? Is it for an injury? Is it for?
I think it's for, I could have sworn he was in a motor vehicle accident, but what, are you on pain medicine for injury or what?
I was in a wreck, but I haven't been using.
You're still testing positive for it?
When the last time I tested positive?
Last week.
I wasn't positive for it.
No.
Or
tested positive?
We were here on, was it Thursday or Wednesday of last week?
Last week, I did not test positive.
This is Mr. Bennett. When was his last UA? Please. If you're clean, I'm jumping up and down. Really?
That was the 17th. You told me the same thing, and I went and did my drug test, and I ain't have it in my system.
Let's see. I don't know. The last one I showed.
An email that he did, so that's why I assumed that he did, but I don't know.
That's what I got too.
Last time I did a drug test, it wasn't in my system. They shake the bottle and show you right in your face.
His last drug test was on the 22nd, so it was yesterday.
And
no, I didn't.
Results?
They were presumptive positive for THC.
That's it?
That's it.
Okay.
Wonderful. That's great. I'm proud of you. Great job. Great. I'm going to test you like crazy still. Don't use. Please. I'm going to let you go for the time being for the weed. But, after about 50 days, if you're still testing positive, that means you're continuing to use. Just don't. All right?
So,
okay, we're good. I'll continue supervision. Okay, great. All right.
It's a regular coordinated was June 3rd, so we're just come back on that. All right.
Good job, Mr. Bennett. Really, great job. Hey, did you file conditions on bias? That was the reckless driving also.
Can you sign bond conditions?
Yeah, I'm doing it right now. Right.
Bilal Al-Zabani, come on up.
Hey, Roxanne,
Come on.
I always waive all fees. Unless I tell you otherwise, assume that the fee's waived. So like in Emma Lynch's PR bond, I'm gonna check the waive fee so that she doesn't have to worry about it, okay? Look at how much she would have to pay. Look at for the bond for Lynch. That would be $450, you know? So no, it's okay, but the presumption is that it's always waived, all the fees.
Yes, your attorney will prepare you, so just stay in contact.
Guys, you ready?
Judge, I'll just have a motion, but other than that, that's okay. So.
You're gonna do it now?
Well, I'm fine.
Oh. Please.
Yes, I got them reading. I got them.
You're here. You're here. Guys, we are going on the record. Please do not talk. If you need to talk, please go outside. Okay, so we're back on the record in the trial case, and before I ask the state to call its next witness, Ray, did you have something that you wanted to do?
I do, Your Honor, and just wanted to ask the court, I would file an oral motion to suppress any evidence obtained from the traffic stop. I don't believe there was probable cause for the traffic stop. Officer Metter indicated that he could not tell how fast he was going. That it was less than a quarter of a mile before to the next light when my client was stopped. It took over a minute for them to get there. Therefore, whatever speed Officer Metter perceived is inaccurate. He even indicated so himself. Also, Judge, at the same time, Officer Metter said that if it's not for his perceived speeding, he would never run my client's license plate. And I don't believe with him not running the license plate, he even indicated that had he not perceived him to be speeding, he would have never ran his plate and therefore would have never found out about the expired registration. And on top of that, the officer also testified that the expired registration in and of itself is not indicative of driving while intoxicated. I don't believe there was probable cause to pull him over based on the inability of the officer to say how fast he was going. And I don't believe that without that reasoning, he would never run his plate. If he would never run his plate and found out the expired registration, he would never got into the field sobriety test and we would not be here. So I'd ask for all evidence to be suppressed based on the fact that the officer did not have probable cause to even run his plate or stop him to begin with.
Okay, response?
Your Honor, the state would offer that there are several arguments being made here. The first of which is that the officer's suspicion was initially triggered based off of what he believed to be speed. He then follows that up with pasting, a method that is commonly used and applied by law enforcement. And he also verified that his speedometer was calibrated that day. Because of that, he was able to pace the defendant at a speed that, even if it was not the speed of 64 miles an hour that the officer testified to, he knew that it was at least above the posted speed limit, which on its face is enough for the officer to initiate the traffic stop. However, the officer did not stop there, he went further. And even if that part of pacing is not accepted by Your Honor, the next part that the state would argue would be that the officer's initial suspicion was triggered. He continued to have suspicion of the vehicle. And then once he got up to the vehicle, he ran the registration. As he testified, he can do on any vehicle, as is commonly accepted. That once he found that the registration was expired, he then initiated a traffic stop at the next possible moment to do so, which because of that expired registration on its face is sufficient sufficient for the officer to initiate the traffic stop.
Okay, I get it. I'm going to deny your motion. I mean, I think that there's enough to go on. You know, officers, the training and experience, it's a 30-mile-an-hour road. They know when it's faster than that, and then they can run the license plate for, you know. I'm going to deny the motion. Sorry, Your Honor. Okay. State, are you ready to call your next witness?
Yes, Your Honor.
Okay. Guys, we have a jury coming in. Or hold on a second. Hold on. Mr. Bias, come up. We'll have you sign so we can get you out of here. Is there anyone else that we need to get out? Okay. Lawyers, anything else that anyone wants to talk about real quick? No? Bueller? Okay, let's go.
Just at lunch, Your Honor, we were going to make sure all our redactions were good, and we were going to go over that at lunch break.
Yeah, we'll do that at lunch. And at least get through one more witness before lunch.
Yes, Your Honor. Can you get the jury first?
You ready? All right, let's go. Come on, get them. Bring it.
All right, for the jury.
Okay, ladies and gentlemen of the jury, we're going to continue now with the state's next witness. Everybody please be seated. Who's your next witness, State?
State calls Officer Nicholas Ruiz Flatland to stand.
If you mind, Deputy Miranda.
Your Honor, this witness has not been sworn in.
Okay, Deputy Ruiz, come on up. Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Any testimony you give will be the truth.
I swear.
Please take a seat. And I ask you to speak loudly, clearly. If you hear the word objection, just stop until we address it, and then you may continue. Okay? Okay, State, please.
Judge. Officer, would you please state your full name for record?
Nicholas Ruiz.
And what do you do for work?
I'm a police officer with the Eastern Police Department.
How long have you done it for?
Approximately 2 years.
And what kind of training do you have to be an officer?
You have to go to the Eastern Police Department's Academy for approximately 8 months.
And what does that involve?
It involves training, case law, the criminal code of procedure, things like that.
And officer, in your experience, have you ever been involved in a DWI investigation?
Yes, sir.
Can you approximate how many DWI investigations you've been involved in?
Numerous amounts.
And officer, how many languages do you speak?
I speak 2 languages.
What languages are those?
Spanish and English.
Which language was your first?
Spanish.
And have you continuously spoken Spanish your entire life?
Yes, sir.
Do you frequently use Spanish in your job?
Yes, sir.
Have you ever had problems with people understanding your Spanish?
No, sir.
If they do they indicate that to you?
Yes, sir.
And how would they indicate that?
By asking me to repeat what I said.
Do you recall October 6, 2024?
Yes, sir.
And were you on shift that night?
Yes, sir.
How did you come to be involved in the incident we are here for today?
Officer Matter requested for Spanish speaking officer, and I took part.
And when you got there, what'd you see?
I observed the defendant to be in a vehicle, and then Officer Matter asked me to step out and stand.
And when you say the defendant, who do you mean?
And I said it was a Christian on the phone.
You understand that's in the way to reflect that the witness has identified the defendant.
Okay, it will reflect.
Thank you, Your Honor. All right, so you get to the vehicle.
That's right.
What did you notice in your interaction with the defendant?
Upon making contact with the defendant, I observed his speech be slurred. I could smell alcoholic breath and committing from him.
And you said his speech was slurred.
That's right.
And you're all right, and what did you do after that?
At that point, Officer Matter advised me to translate what his instruction for the SMFPs for English Spanish.
Before that, did Officer Metter have you translate anything else?
That's right. He asked me to translate the probable cause for the stop.
And after you translated the probable cause, what did you do?
I advised him, Officer Matter asked me to translate the SFSTs.
And when you were translating the SFSTs, did you encounter any problems in translating those for the defendant?
No, sir.
How do you know that?
I repeatedly spoke to this, saying to the defendant he understood, and he shook his head, saying yes.
At any point, was there any indication to you that he did not understand what you were saying?
No, sir.
All right, so after the SFST, what did you do?
I read him the DIC 24 or the DIC 24, the statutory warning against Spanish.
Okay. And did he indicate to you that he understood?
Yes, I asked him and he understood.
And what did the defendant say after you read the DIC object?
I asked him for a sample of breath to which he consented. So he asked me why he was being arrested. I told him that he was being detained.
And did you have any other involvement after that?
No, sir.
Senator, may I approach? Yes. I'm showing you what's marked as State's Exhibit 3. Is this the form that she indicated you read to me?
Or any of the
Yes, you can.
Yes. Yes.
To clarify for the record, what form is this?
The duration of creative suspension. Yes, it was.
And you confirm that you read the certificate? And he understood it when you read it to him? Say that's the way, Sean.
You might put your answer.
Please.
So you're saying this is the form that you presented to him, read to him, correct? That one. I call it, Your Honor.
Yes. What, is it in evidence? Which form is that?
Oh, I'm sorry, this is State's Exhibit 3.
As far as I can see, only the DIC 25 is in evidence now, right?
It was the entire packet.
Sorry?
Your Honor, the entire packet was,
Okay.
I believe, so it's marked to State's Exhibit 3.
Okay. Okay, so this is the form you read to them, correct? Yes, sir. What does that form explain?
The duration of the periods for suspension. So just based on whenever you commit the first crime, like 180 days, 2 years.
Okay. Doesn't say anything about his rights or anything like that, correct?
No, sir.
Doesn't ask him for a breath sample or anything like that, correct?
No, sir.
All it talks about is his license suspension, correct?
Yes, sir.
Now, you indicated that you observed slurred speech, is that correct?
Yes, sir.
Okay. Would you have any reason to disagree? You weren't the lead officer, correct?
No, sir.
Who was the lead officer?
Officer Redmond.
Would you have any reason to doubt Officer Medder's observations and opinions?
No, sir.
Is he more senior to you?
Yes, sir.
So if Officer Medder testified that he did not observe slurred speech, somebody is wrong, correct?
Not exactly, sir.
Okay, well, if Officer Medder testified that he did not observe slurred speech, would Officer Medder be wrong, or would you be wrong in observing slurred speech?
I observed slurred speech. I'm not going to testify to what you observed, but I observed slurred speech.
But you have no reason to doubt what he saw and what he testified to, correct?
That's correct.
Now, as far as you know, you've never spoken to my client before, right?
No, sir.
So you don't know what his normal speech patterns are, correct?
No, sir.
So you don't know if that's just his normal speech?
No, sir.
You don't know if he has a speech impediment, correct?
No, sir.
I'm not going to show you. Maybe a breakdown.
Say it again.
I've never burned the declaration just yet. I have the declaration downloaded on the computer.
Okay,
Can we play the declaration on the computer?
sure. I mean, as long as you're okay with it. Yeah.
That's
You mean how? Well, what is it for?
This is the body cams.
Okay, you want to do it? Just kind of show it to them, I guess? Like put it up on the podium here or?
Or we can put it through.
Oh, there?
Yeah.
Oh, okay. Yeah, yeah.
It's just
I don't care. Yeah. As long as you're okay, both parties.
This is where that's gonna go back. All right, so this is State's Exhibit 2. Yeah, State's Exhibit 2. Okay, so that's you right there, correct?
That's correct.
So I don't get his bill, he was, the reason for the stop, he's traveling 64 miles an hour and 35, and his registration expired November of last year.
La razón que te paramos es porque estabas manejando 64 millas por hora en una lugar.
Okay, right there, what did you just tell him?
I told the probable cause for stopping.
And what exactly did you say was the probable cause for the stop?
That he was driving 64 miles an hour in a 35 area.
Did you see his reaction when you told him that?
No.
Registration expired November of last year.
La razón que te paramos es porque estabas manejando 64 millas por hora en una lugar.
That's not correct.
Okay, what was his reaction there?
Surprise.
Okay. Would it be fair to say that it seemed that he was disagreeing with what Officer Med was saying or what you were translating?
That's right.
Where's he coming from?
De la casa, un piso de la casa. Sí, no le vio solo. This was wrong.
He says he's coming from home. ¿10-4?
Lo que comento lo hace porque estamos.
What was he saying there?
That he was helping someone to move.
Helping somebody to move, correct? Okay. But you didn't tell Officer Metter those words, did you?
I said he was helping a friend move.
Sorry?
I said that he was helping a friend move.
At this point, you said that?
Wait.
Entonces, apenas digamos, lo repartimos lo que comento lo hace porque estamos. Entonces, yo estaba ayudando a mi mamá.
So he's coming from Cleveland or he's coming from South
Oh, so he's saying he came from Cleveland and do something and started he's trying out, we're down here because the gas is cheaper.
Okay. You heard him say earlier that he was going to his friend's house, correct?
That's correct.
You didn't translate that to Officer Metter, correct? At this point? You just said he came down here for gas is cheaper, right?
Well, I mean, he said he was helping a friend move in Spanish, and I told him that he was coming from Cleveland, he was coming from there, and that he came from here. The whole statement that he provided was very
I'm not, the state can ask questions if they need to. What I'm asking you is, your translation was not entirely accurate as to what he was saying, correct?
Are you referring to, was it verbatim?
Yes.
It wasn't. It was paraphrased.
It was paraphrased, correct?
That's correct.
So some things were left off, correct?
That's correct.
Okay. And then later on, okay, so just to make sure I'm clear, you didn't translate verbatim, you just gave summaries of what he was saying to you, correct?
I paraphrased what he was saying.
Paraphrased. Do you feel that it would be important, especially for Officer Metter, who's the investigating officer, to have exact translations so that nothing is missed?
That's correct.
And do you feel it should have been, if things were missed, and Officer Metter does, as far as you know, Officer Metter doesn't speak Spanish, correct?
That's correct.
Yeah. So if you didn't say certain things at all times, is it possible that you may have relayed inaccurate information to Officer Metter?
That's not correct. I just paraphrased the translation.
Okay.
I didn't say anything that was incorrect, just basically what he was saying.
But you didn't say all of the facts, correct?
That's correct.
Okay, so if some facts were missing, it's possible that Officer Metter may have thought that there were inconsistencies in his statement, correct?
That's correct.
Nothing further, Your Honor. Okay. Anything further?
Yes, Your Honor.
Be brief.
Yes, Your Honor. Does Officer Metter know Spanish?
No.
Can you tell if somebody has slurred speech, generally speaking, if you don't know the language?
That's correct.
Sorry, let me clarify. Is it hard to tell if someone has slurred speech if you don't know the language?
No, sir.
It's not hard to tell if you don't know the language.
No, sir.
Your Honor, may I approach?
Sure.
Showing you what's been marked as State's Exhibit 3. I'm showing you the first page of what's been marked as State's Exhibit 3. Did you read this for the defendant?
I'm going to object, Judge. I think this has been answered.
Has he already answered that he has done this?
Judge, defense counsel asked several questions that I believe need to be clarified for the jury on exactly what he read to the defendant. Especially.
Has he already testified that he's read this?
He testified that he read the periods of suspension. That's what he testified that he read, and I believe that that's his testimony. The state going back this question has already been asked and it's already been answered.
No, because this is this is not the DIC 25, right? This is the DIC which one?
Your Honor, I would like to go through, there's 4 pages here. I'd like to go through and clarify exactly what pages and what he read to the defendant.
Okay, overruled.
And Judge, my objection to that is this is the same exhibit. He had an opportunity to view that exhibit when they were asked and after, when he was presented with it. He went through and he indicated both on direct and cross-examination.
I don't want to limit his direct though, you know, okay, overruled. You may continue.
Did you read this page to the defendant?
Do you mean like, is it saying something?
Yes, just did you read it?
Usually what was written with the DSC section.
Okay. Okay, so you read what's marked as page 2 of State's Exhibit 3, correct? Okay, you're indicating to me that you read what's marked as page 3 of State's Exhibit 3, correct? Okay. Did you read anything off page 4? Would you ever do?
No.
Why not?
Because I'm not the arresting officer.
Just to clarify. Okay, so I'm showing you what's going to page 2 of State's Exhibit 3. Did you read this to the defendant?
No.
You just testified on cross-examination that you read that to the defendant.
Yeah, I got confused with the other one.
Okay. I'm showing you page 3 of what's marked as State's Exhibit 3. Are these the statutory warnings that you read? Did you read those to the defendant? And what does this say? What is on here?
Basically, why he's being detained. And then we asked him for a sample of breath and what are the consequences of him saying no to a sample of breath and or blood.
And what did he say when you asked him?
He said it's not visual.
Is that visible on here on this form?
Yes.
Where does it say?
Right there, right where he signed or where I'm asking.
Where does it say that he consents?
Right at the bottom where it says consentimiento, right next to it says firm signing. That's where he signed right next to it. And where that checkbox is him saying that he's giving consent to the taking of his breath.
And is that his signature?
That's correct.
Now, officer, you mentioned you were paraphrasing a little bit. How often do you use Spanish in your job to translate for investigations?
All the time.
When you're translating, do you translate what is being said verbatim?
On some occasions I do, and some occasions I translate paraphrase.
On the standardized field sobriety test, did you translate them verbatim?
I don't know.
Why, when you're translating something, would you not translate it word for word?
Because the translation from English to Spanish is different. Some words wouldn't make sense.
Were the general instructions the same, or were the general instructions that you gave the same in Spanish that Officer Metter was instructing in English?
That's correct.
And was that true for the entirety of your interaction in this instance?
That's correct.
Nothing further than say no.
Briefly, Your Honor.
Yes, sir.
But that's actually not true, correct, Gazelle? Correct? It's not true that you translated verbatim everything, correct?
That's correct.
Yeah. So when the state just asked you if that was what you did for the entirety of the investigation, that was the false answer, correct?
No, sir.
Well, they asked you, did you translate verbatim for the entirety of the investigation? You said yes.
He asked me in some instances during investigation. I'm not sure if he asked me for this case specifically.
Oh, no, he asked you for this case.
I'm not about that.
So is that because you got confused again?
No, sir.
When you got confused, you said you got confused as to which form you read.
He didn't ask me if I translated verbatim. I told you before I paraphrased what he was saying.
Okay, so it's possible you paraphrased the instructions as well, correct?
No, sir.
And what about the DSC form? You testified on direct and on cross-examination twice that you read him the suspension period page, correct?
That's correct. I got confused.
Well, you would agree with me that there's a big difference, even in Spanish, between something that says these are the periods of suspension, these are your rights under the law, correct?
That's correct.
And as far as different languages in understanding slurred speech or noticing slurred speech, it's possible that even if you don't speak the language, you can still tell if somebody has slurred speech, correct?
That's correct.
Nothing further, Your Honor.
May this witness be excused?
Yes, Your Honor.
All right. You're done. Thank you so much for testifying. Stay safe out there. Do you have any more witnesses?
Two more witnesses, Your Honor.
Guys, you want to go through one more? What say you? Keep going? Lunch isn't here yet anyway, so. Okay, call your next witness, please.
State calls Donald Varner to the stand, Your Honor.
Come up, sir.
Your Honor, this witness has been sworn in.
Okay. Will you be so kind to raise your right hand? Will you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Any testimony you give will be the truth?
Yes, sir.
Please take a seat. Please speak loudly, clearly. If you hear the word objection, just stop. We've addressed it, then you may continue. Okay.
Hey, Judge. You may say your full name for the record.
Don Varner, Visa Victor, AR.
And what do you do for work?
Work for the city of Houston as a DWI technician.
And can you briefly describe your education and training you had to have to hold that role?
Yes, I went to the HP Academy for standard field sobriety test for SFC. 40-hour class with continuous education with the state of Texas to become a top lifer and go to the law school.
And how are you licensed?
Wait, what area?
How are you licensed? Are you licensed to operate an intoxication?
Yes.
And how are you licensed?
With the state of Texas, take an exam every year and at least a minimum 5 drug tests a year.
And how long have you been licensed to do?
10 years.
And what instrument are you licensed to operate?
9,000.
Do you have your current license?
Yes.
Have you had any other special training or attended any special courses pertaining to your duties as an intoxication operator?
Yes.
What kind of training?
A standard field sobriety test
Give your voice back.
and the longest.
And just to clarify, do you presently hold a license from the Texas Department of Public Safety as a qualified operator of the intoxicator industry?
Yes.
And how often must your license be renewed to retain or to remain a qualified operator?
Every year.
And when were you last licensed?
October the 31st of 2024.
And was your license current on October 6th, 2024?
Yes.
And were you on shift on October 6th?
Yes.
On that date, did you administer an intoxication test to the defendant?
Yes.
And to the defendant, for the record, can you, is the defendant in this room?
Yes.
For the record, can you point to the defendant and describe an article of clothing?
Yes, a long sleeve button shirt, black and white.
Your Honor, just say with us that the record reflect that the witnesses identified the defendant.
Okay, well.
Prior to administering that test, was the defendant continuously in your presence for at least 15 minutes?
Yes.
Why do we do that?
To make sure the BAC, in this case, breath alcohol concentration level is as accurate as possible.
How does that ensure that it's accurate?
By me being in the same area, at least 15 minutes, and to observe that they didn't put anything in their mouth, or having gum, or vomit.
Did anything like that occur within that 15 minute period?
No.
Did you check to see if the defendant had anything in their mouth?
Yes.
Did it?
No.
What intoxication model did you use to conduct these tests?
The 9,000.
And do you recall the serial number of the machine that you used?
Yes.
What is that serial number?
90001482.
And can you please explain to the jury how an intoxication test?
I'm in the same area with whoever's providing the breath sample to make sure they don't vomit or throw up, because you want to be as legal as possible. Nothing like that occurs. You turn on the instrument, do a cycle, put the subject's name, date of birth, and verify that you've been watching for 15 minutes, your signature, and then go through the process.
And can you go into that process?
Yes. The instrument itself, it goes through an operation check, then an air blank, and then calibration verification check, and then solution temperature, then an air blank. Then the subject will do the first test, air blank again, air blank, second test, air blank, calibration verification check, solution check, air blank, and an operation.
Can you explain when you're saying air blank? What does that mean?
In the last results, it's the solution is trying to make the first results to be triple zeros. So when you get the second results, there's no BAC, in this case, breath alcohol concentration in the last results.
And is that a solution to ensure that the intoxilizer is performing?
Yes.
Were those tests done in this case?
Yes.
Gentleman, may I approach?
Yes.
I'm showing you what's marked as State's Exhibit 4. Do you recognize this?
Yes.
What is that?
It's the results of the breath test.
And you see the results. What does this exhibit indicate that everything was done properly?
Yes.
How do you know that?
It would that could be a valid test if anything occurs with the instrument. It would give you a incomplete test and give you a reason why it's incomplete.
And whose signature is at the bottom of that page?
That's mine.
And what were the results of this test?
That's a question a technical supervisor in the state of Texas would have to answer.
And what I've showed you with State's Exhibit 4 previously, was this the exact test that was used on that day for this defendant?
Yes.
And as we've gone over this a little bit, but as part of the automatic operation of the intoxilizer, does the instrument perform an operating system check before each test?
Yes.
And are the results of that certain exam entered on the analytical report?
Yes.
And what were the results of that?
Direct Your Honor.
Sustained.
And what's marked as State's Exhibit 4, what I just showed you, is that an original or a duplicate?
I'm sorry, can you repeat?
What I previously showed you was been marked as State's Exhibit 4. Is that an original or a duplicate?
To the original copy, I'm not too sure it's the original form itself.
State pass the witness, Your Honor.
Can I proceed, Your Honor?
Please.
And Mr. Varner, you indicated that part of your process is to make sure that the defendant is in your view for at least 15 minutes before administering the test. Is that correct?
Yes.
And it has to be 15 minutes, right?
Yes.
And what is the reasoning behind that?
To make sure that the AC level is accurate at that time.
And that you're supposed to do that on every single breath test, correct?
Yes.
You didn't do that on this case, correct?
No. I'm sorry, can you repeat the question again?
I said you didn't do the 15-minute observation period on this case, correct?
No, that's not correct.
So you did do 15 minutes?
Yes.
And you're absolutely positive about that?
Yes.
Just as positive as you are about the breath test and that intoxilizer working accurately, correct?
Yes.
No doubt in your mind whatsoever?
No doubt.
May I approach Your Honor? And we'll probably need a break, Judge. I've got some videos I need to show him.
Okay, you can take the jury out, please. Jurors, we'll take a 5-minute break. I'll bring you back in and we'll continue. Okay.
All right, for the jury.
Please be seated. Ray, what you got? Have you seen this place? Do you know?
It's evidence.
That's not.
No, it's not evidence, but it's an interrogation.
Okay, got it.
Sorry.
Hey, guys, is there anyone else that needs anything? You have one plea. You do? You have a plea? Tony's here. Kill two birds with one stone. Hey, while you're discussing, can we do a plea?
Yeah, I'll take your option.
Okay, bring him on. Tony, do you mind helping us out with this plea real quick?
Let me get.
You have the paperwork? Or you would sign?
Yeah, I think I was fine.
Sure.
Yeah. Yeah.
I saw Sarah's been sitting here too. Does she need something? Do you know?
Every single thing's done.
Yeah. Ray, do you want this on the record or no? Okay. Off the record. No, we're good.
Oh, it doesn't work.
No. They were talking. Ms. Morgan, who is this?
Is this Ben here, Your Honor?
Oh, they're making it.
Entonces los que lo que son.
Yeah, I guess so. Just so y'all can go do whatever you need to do. Yeah.
We'll find out when this was, so we can get it cleared up.
Like, does she get the place in here? What's your name, ma'am?
So choose my proposal victim yesterday and Lewis today. They were trying to discuss it. They were going to, they were gonna.
Oh, okay.
Yeah, Moreno.
Moreno?
Yeah, Valeria.
Moreno,
Moreno. It's way from here. She didn't even have to be here. So it's probably getting reset. So we'll talk to Vic and see. Victoria.
Yes, Judge.
Have you heard from Michael Fan?
No, Judge.
Come on. All right, you are Mr. Denehia Nunez.
Yes.
You were charged with 2 counts of driving while intoxicated. You have worked out an agreement where they're going to dismiss one of them. You're pleading to the other one. It's 75 days in jail with credit for the 25 days that you have done. Is this how you understand the agreement?
Es el mismo acuerdo. I'm sorry, Judge.
Is this how you understand the agreement?
Entiende que era el acuerdo. Yes.
Giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, this will go on your record. It's going to be there forever.
Permanecerá ahí por siempre. Yes.
from now on,
De ahora en
if
adelante.
you ever get pulled over, an officer is going to see all these DWIs. And if you smell like alcohol or dope, it's probably not going to go well for you.
Ahí bien.
Every day, someone dies from a DWI in our nation, in our state, in our county. Don't kill anyone.
Mate a nadie.
No mates a una persona. Because of these DWIs that are with you now, I'm telling you, anytime you get pulled over, you have a funky smell. It's probably not going to go well. So if you're going to drink, if you're going to have 32 shots of tequila, 52 beers, don't get into a car. Do you understand?
Yes.
I'm going to suspend your license for 1 year.
Su licencia por un año.
Okay. Do not drive until you get a license. The other thing I'm going to tell you is I don't know what your immigration status is, but if you're not in this country and you continue to come back without permission and you get caught by the feds, it could be a 5-year federal sentence on an illegal reentry. So be careful. If you want to do things, do it the right way.
Hágalo de manera correcta.
How do you plead to the offense? Guilty or not guilty?
No culpable.
Culpable.
Guilty.
Find you guilty. I'm going to send you to it. Good luck to you, son.
Buena suerte, señor.
Okay, thank you.
Okay.
Thank you, Your Honor. May I be excused?
I'll sign it. I just haven't put it in, I'll sign it. Vic, I don't know what to do about Miss Davis, but it's 12:30 and I mean, you haven't heard from Michael, so.
No, he did swing by earlier,
Okay.
but I think we had started already, so he left. I'll reach out to him and see if he can come back.
Well, I'm, it's already 12:30. I'm willing to, set it for, next week if she wants.
Okay, I'll let him know.
Okay, thanks. We'll set you off to next week, man. We'll let you pick the day, whatever day you want.
Say to call and whenever you're ready.
Yeah, we'll let him know and then we'll get you out of here momentarily. Shouldn't have to sit here and wait. Okay. Family, you ready? Ready?
I think the state wanted to address an issue with you regarding the videos, Judge.
Come talk to me.
I'll try.
What's the word?
So,
do you want to record?
yes. You want to just informally? Yeah, we could do informal first and then.
Okay, sure. So we're not on the record now?
No, not right now.
Okay, talk to me.
So what I was showing him is the video from the in-talks room in JPC, where it shows that he comes in and then 6 minutes later is when he actually does the test. What they're informing me is that the observation period began outside, but there's videos from the outside, which we don't have. So there's no way of us to confirm the 15-minute observation period. I'm asking for these to come in just so I can make that argument. I think the state's going to object to it as to the weight of the evidence. That's so I'm just.
You're objecting to him having admitting this evidence?
I thought you said.
No, no objection to the videos coming in. No. If you want to do that, that's fine. I'll just, I'll go back. And
I'm gonna let it in regardless. I was gonna let it in.
I thought you said something about the weight of the evidence.
No.
I was saying if you are objecting to like some kind of a breath test, saying, well, the breath test isn't good because we don't have this video, I would just say it's not
Is there a time that delineates when he was actually arrived at the station?
No.
Come on, there has to be.
There's not.
They're always this. They document damn near
The
everything.
offense report, man.
The offense report does, but he can't testify as to the offense report.
No.
Yeah, that's. Sarah, do you need anything before we start up? No? Okay. So let's go. You ready? No, I want to see how far we can get, Do you have any witnesses?
I don't have.
Yeah, just literally just have them eat, deliberate and eat. You ready?
What's the food?
Pizza. So I'm sure that they would run to get it and. So you're starting right now, right?
Yes.
You haven't done anything yet so far, am I right?
No.
Right. Josh.
It's just a USB drive.
Oh, I remember.
Since you don't want to.
I mean,
You're
leave your cell phone for it and it shows.
All right, for the jury.
Okay, please be seated. Ray, you may continue.
May I approach, Your Honor?
Please.
And I'm sorry, do you have an official like title or designation or? Is Mr. Hartman?
Yes.
Okay. Mr. Hartman, during the break, I showed you some videos, correct?
Yes.
And those videos were contained on this USB drive, correct?
Yes.
Okay, and as far as you know, the videos that you observed are a fair and accurate depiction of what happened at that time, is that correct?
Yes.
And to your knowledge, have they been altered or modified in any way?
No.
Generating to opposing counsel for objections?
So this would be defense one.
Defense one, yes, Your Honor.
No judgment was said, Your Honor.
Okay, it'll be admitted, and that is a USB of the intox room?
Yeah, that's correct, Your Honor. Two separate views from the intox room. May I publish, Your Honor?
Please.
All right, Mr. Varner, so this is the intoxilizer room at JPC, is that correct?
Yes.
And this is where suspects are taken in for their breath test, correct?
Yes.
Okay, so who do we see here in this video?
Me, Officer Metter, and Reno. Got a mess. Got a mess.
Close enough. Okay, so my client, you and Officer Metter, correct?
Yes.
Okay, and we're about the 1 minute 14 second mark, correct? Can I hear
Yes, sir.
Okay. Well, I'm just going to fast forward a little bit because there's a lot of sitting around, is that right?
Yes, sir.
Okay. Okay, is this when you begin the breath test?
Yes.
Okay, and we're at the 6 minute and 45 second mark, is that correct?
Yes.
Okay. Is that 15 minutes?
1:45 to 6:45, no.
And so this is where you begin the breath test, correct?
Yes.
Now you indicated on direct examination that you also check their mouths before they blow, is that correct?
Yes.
We don't see you check his mouth there, do we?
No.
Okay, and then this is just him blowing into the device, correct?
The first sample, yes.
Okay. And then there's a waiting period and then the second sample, correct?
Yes.
And as part of State's Exhibit State Exhibit 4. May I approach John?
Please.
Is this your writing on the second page here?
Yes.
Okay. And without going into too much detail, what does it say next to breath?
MOAB.
And what does MOAB stand for?
Moderate odor alcohol beverage.
Moderate odor of alcoholic beverage?
Yes.
And is that something that you observed, or is that what you were told by the officer?
That's what I observed.
Okay. So not a strong odor of alcohol, correct?
No.
And in your experience, how many times have you administered a breath test?
Almost 3,000 a year.
3,000 a year?
Yes.
Okay, so in all of those times, if they had a strong odor of alcoholic beverage, you would indicate that, correct?
Yes.
They had a moderate odor of alcoholic beverage, you would indicate that, correct?
Yes.
They had a mild odor of alcoholic beverage, you would indicate that as well, correct?
That would be moderate, it would be mild, or distinct.
Okay, so a difference between strong and moderate / mild, correct?
Yes.
And would you agree with me that just even a couple of beers could provide moderate odor of alcohol, correct?
Yes.
I'll pass it to the judge.
Okay. Anything further?
Briefly, Judge. Was what we saw in the video the entire observation period?
No.
Why not?
So the APC, we have limited space and we have not as talks about the first people. And we don't have enough time to wait on room, so we have to observe outside before we go to the room or somebody else to use the room.
Did you do that on this test?
Yes.
And was the full 15-minute period observed?
Yes.
And did you check his mouth before?
Yes.
Was everything you did on this specific test done in accordance with your standard procedure?
Yes.
Nothing further than to say.
Okay.
Right, very briefly, Your Honor.
Okay.
And Mr. Varner, just so we're clear, there are, this was done at the JPC, correct?
Yes.
And that stands for a Joint Processing Center, correct?
Yes.
And there are cameras all throughout JPC, correct?
Yes.
But you or whoever's in charge of your videos did not provide either the state or myself the video of the observation period outside, correct?
You're correct.
So the only thing that we can physically see is the 6-minute time period between the time you enter the room and the time you do the test, correct?
Yes.
Nothing further, Judge. Okay.
All right, may this witness be excused?
Nothing further than to say.
No recall, right?
No recall.
Okay. Mr. Varner, you're excused. Thank you for your testimony. Be safe. Do you have one final witness?
Yes, Your Honor.
Okay. Do you want to keep going, last witness, or do you want to? All right, state, call your last witness.
They call Stephen Cooper to stand, Your Honor.
Okay.
Give me some pressure, Your Honor.
Your Honor, this witness has not been sworn in. Okay. All right, Mr. Cooper, can you come on up? Good afternoon. Good afternoon. Come on, please raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Any testimony you give will be the truth.
Yes.
Please speak loudly, clearly. If you hear the word objection, stop until we've addressed it, and then you may continue. Okay? All right. State.
State Judge. Can you please state your full name for the record?
Stephen Cooper.
And what do you do for work?
I am a forensic scientist as well as a technical supervisor.
And how long have you done it?
For about 7.5 years now.
Can you tell the jury a little bit about your educational background?
So I have a Bachelor of Science degree in biology from the University of Texas at Arlington, as well as a minor in biochemistry.
And do you hold any memberships in scientific or professional organizations?
Yes, I am a member of the International Association for Chemical Testing as the website chair. I'm also the past president of the Alcohol Testing Alliance.
And what are your current duties and responsibilities as a technical supervisor?
So they include being a custodian of records of all breath test records generated through the Texas Department of Public Safety for the area that I cover. I also train operators on the use of the Intoxilizer 9000. I testify in court for DWI trials, and I'm also in charge of the Intoxilizer 9000s in my area, performing any maintenance and inspection as needed.
And what is the Texas Breath Alcohol Testing Program?
So that is the program that oversees all Intoxilizer 9000s in the state of Texas, as well as operators being trained on the use of them for all breath DWI investigations being conducted.
And are you presently certified by the Texas Department of Public Safety as a technical supervisor?
Yes, I am.
What date were you certified on?
It was in December of 2017.
And what training do you have to have for that certification?
So it includes a several month-long training process, usually around 6 to 8 months. It includes attending various training courses taught by other technical supervisors in the area throughout the state of Texas. You also must attend various training courses outside of Texas. One of which being the Borkenstein class hosted through Indiana University, where you learn about the physical and mental impacts of alcohol in the body. You also must attend a course hosted by CMI, the creators of the Intoxilizer 9000, where they teach you how to perform maintenance of the Intoxilizer 9000. You then also must go through operator school, go through a mock trial process, and then have a written and oral test conducted.
Have you conducted any experiments on your own as to the workings and the reliability of the Intoxilizer 9000?
Yes, I have.
Are you familiar with the underlying scientific theory that the Intoxilizer 9000 instrument is based upon?
Yes, it's based upon infrared spectroscopy.
Can you explain that? What's infrared spectroscopy?
So essentially, in our instrumentation, you have an infrared light source and a photodetector analyzing that infrared light source. You can sort of envision this by, say, you're standing in a hallway holding a flashlight that's emitting light, and you have a friend at the other end of the hallway staring at the light coming out of your flashlight. Now, if you can sort of envision the hallway filled with something such as smoke, the more smoke that enters the hallway, the less light your friend is going to see. So similarly, in the instrumentation, the more ethanol on an individual's breath that fills the test chamber is going to absorb this infrared light, the less light the photodetector is going to see. And now the instrument is calibrated that as the light it sees increases, the concentration of ethanol in the chamber goes up. So it has a proportional calculation that it does at that point.
And is that theory considered valid by the scientific community?
Yes, it is.
Can you explain a little bit more about how the instrument specifically applies that theory?
So it's kind of applying it through what's referred to the Lambert-Beer law, stating that a constant temperature of pressure absorption is proportionate to concentration.
And was that technique properly applied in this case?
Yes, it was.
How do you know that?
It's the scientific basis behind the Breathalyzer 9000. The instrumentation related to this have been around for decades now, and there's much research behind this.
Do you know an intoxilizer operator by the name of Donald Varner?
Yes, I do.
Is Mr. Varner certified by the Texas Department of Public Safety as an intoxilizer operator?
Yes.
And are you familiar with the Intoxilizer 9000 that was used in this case?
Yes, I am.
How are you familiar with that instrument?
It's an instrument in my area that I'm regularly responsible for.
And has the Intoxilizer instrument model 9000 been approved and or certified by the Texas Department of Public Safety?
Yes, it has.
Was this particular instrument certified and operated as part of the breath alcohol testing program?
Yes, it was.
And as part of your duties, you stated you're responsible for the maintenance and monitoring of the instruments in your area. Can you describe to the jury what this involves?
So one of the first things that it involves is conducting our monthly quality assurance inspections. We travel to each of our locations throughout the Houston, Galveston, and Brazoria County area that are hosted in various courthouses and police departments. The first thing that I do upon getting there is ensure that the instrument is functioning properly. We also have a simulator device attached to the side of the instrument. It contains a known concentration of 0.08 in it, and we replace that on a monthly basis, and then we run a practice test. I also blow into the instrument to ensure that it's reading a 0 for myself. And if any maintenance is required of the instrument, I would take care of it, most likely by removing it, replacing it in my lab, or performing some maintenance on site if need be.
And what was the closest date before October 6, 2024 that you checked this particular intoxilizer?
That would have been September 23rd, 2024.
What was the condition of this particular instrument at that time?
It was functioning properly at that time after the technical supervisor initially forgot to plug in the simulator cable. She then plugged it in and had a complete test afterwards.
And what was the closest date after October 6, 2024 that you checked this particular instrument?
That would have been October 22nd, 2024.
And was the operational condition of this particular instrument, what was the operational condition of this particular instrument at the time?
It was functioning properly at that time as well.
And did that particular instrument require any repairs between the dates that you checked?
No, it did not.
And do you have an opinion based upon your experience and training as to the operational condition of that instrument on October 6, 2024?
Yes, that it was functioning properly at that time.
Government approach?
Yes.
Showing you what's been marked as State's Exhibit number 4. Can you tell me what this is?
This is a Texas forensic breath alcohol analytical report.
And as part of a particular test, is the operator required to have the subject continuously in his or her presence for a minimum period of time prior to conducting the test?
Yes, 15 minutes.
And what is the purpose of that 15 minutes?
It's to ensure that there's no residual amount of alcohol on an individual's breath that could falsely lead to higher elevations than what they actually are at.
Does the analytical report indicate the proper operational methods and testing techniques were followed in administering this particular test?
Yes.
How can you tell that from observing the analytical report?
I can tell that by observing that first and foremost, everything's printed clearly on the page. All of the air blanks are reading 0. The operator's signature is on the page, as well as an indication that they conducted the 15-minute waiting period. There's a test complete indicated on the page as well as no incomplete test messages either.
What is the calibrated verification solution?
So that would,
I'm sorry, what was that?
What is the calibrated verification solution?
So that would be the simulator that I alluded to earlier. It is the reference device containing our known concentration. The instrument reads this twice during every subject test.
Who prepares the calibrated verification solutions for use with intoxilizer instruments?
That would be myself and my coworkers.
How do you prepare these solutions?
We typically will travel to Austin and create them in a large batch. We have a large container containing several hundred gallons of water that we fill up. We add ethanol to create roughly 500 bottles of 500 milliliters. And it contains our known concentration of 0.08. And then we label them, seal them, and then we use them on a monthly basis.
And are those solutions periodically checked?
Yes, monthly.
And how is that done?
That is done at our monthly inspections. We use a new bottle every single time, and then we conduct a practice test with it.
How is the predicted value entered into the Intoxilizer 9000?
So there is no predicted value entered into the Intoxilizer. The instruments are calibrated in our lab, and then the calibration is verified using these simulators with the reference device, with the reference samples in them, sorry. And that's done just to verify the instrument is calibrated properly. And then when an individual blows into the instrument, it uses its calibration to essentially analyze the individual's breath at that point.
Does the analytical report that's marked as State's Exhibit 4 reflect that the result of the calibrated verification system was within the tolerance level of the analytical report value?
Yes, it does.
And what happens if it's out of tolerance?
So if the instrument reads its calibration verification outside of the acceptable range of 0.07 and 0.09, then the instrument will flag an incomplete test with an exception message stating cal verification out of tolerance.
And what happens if it is out of tolerance? Or, I'm sorry, excuse me. No. What does alcohol concentration mean?
In regards to what?
The analytical report says alcohol concentration. What does that mean?
Are you referring to the subject results?
Yes.
So that would be the 2 breath samples that each subject administers throughout the breath test. They provide the first one, and then they provide the second one approximately 2 minutes later.
What steps should the operator of the Interrogation follow in taking a breath sample?
So the first thing that must be conducted is the 15-minute waiting period. Then at that time, the operator will then input the subject's information into the instrument through either scanning, typing, or swiping a driver's license. They then confirm that they conducted the 15-minute waiting period along with their signature, and then they can start the test at that point.
And then can you please describe for the jury the steps the instrument automatically performs?
Sure. So the first thing that occurs during this sequence of analysis is the operational system check. It's when the instrument performs an electronic check on itself to confirm that everything is functioning properly. There's then a 30-second air blink conducted. This is the instrument purging the testing chamber to ensure that there are no foreign contaminants or residual alcohol left behind. The instrument then goes through its first calibration verification check where it checks that known solution that we have attached to it. The instrument will then go through a second air blink to again purge the sample chamber. At that point, the subject then provides their first breath test sample. There is then a third air blink followed by a 1-minute waiting period. And then at that point, it's just a mirror image from what I just went through, ending on the second final operational system checks.
And what were the results of the 2 breath samples of the subject in this case?
I'm going to object, Your Honor, that has not been entered into evidence yet.
What was your question?
What were the results of the 2 breath samples of the subject in this case?
Okay. Good.
And just again, you verified that this is the analytical report that was used for this test, correct?
Yes.
And it's a true and accurate depiction of that analytical report?
Yes.
I'm tendering State's Exhibit 4 for defense inspection.
Improper predicate, Judge.
I'm showing you again what's been marked as State's Exhibit 4. Did you review this analytical report?
Yes.
Does the information here match everything in this case?
Yes.
And this is a fair and accurate copy of that report?
Yes.
Your Honor, I'm tendering State's Exhibit 4 to defense counsel for inspection.
Still believe it's improper predicate, Judge.
Say it again?
I believe it's still improper predicate.
One more. Your Honor, going further.
I can't hear you. Just put it on.
I still live in the court. I'm established.
Mhm.
I'm not established. And I'm not established anymore. I'm not established.
Well, the only thing I would think that is it has been altered in any way, you know?
That's fine. That's fine, Judge. There's still one missing.
Huh?
There's still one missing.
I don't know. I can't think of what you're.
I was going to say, but if you have an objection.
Okay, I mean, just.
May I go to court ex parte? I don't want. If I say it.
Yeah, I just.
She lost her question.
Okay.
Yeah, that's that.
Yeah.
I don't have a problem.
But it's.
Here, I wait for it to move back. This is very bad. So this is, yes, this is not even necessary. In preparation, I'm letting you think about what it's on. This is record of it. I'm established. This is some conflict making. I did it. Without me. So the rest of you still have distinguished that. So, I mean, because they're still in the
I didn't hear you.
they're still in the basket. That's not.
Okay.
Gentlemen,
Please.
All right. I'm showing you again what's been marked as safe and good before. Are you the custodian of records for these types of things? Yes. For this particular one? Yes. Is this the type of record that's kept in the normal course of business for the Department of Public Safety? Yes. Has it been altered in any way? No. Your Honor, the state is tendering to defense counsel for inspection. Objection?
No objections, Your Honor. It'll be admitted.
Judge, you indicated it would be state.
It'll be 4.
Yes, Your Honor.
Okay.
Your Honor, may I publish for the jury?
Please. Still not working. Nothing's working. Radio impression.
And we've already gone over this, but just to refresh, this is the exact document used that is reflected with the results from the specific breath test for this defendant. Yes. And what were the results of that test? They were 0.153 and 0.160 grams per 210 meter. And are these results greater than or less than the legal limit of intoxication set by the state of Texas of 0.08 grams per 210 liters of breath? They are greater than. Good, thank you. With the results of these 2 breath samples within the allowed tolerance specified by the scientific director of the Texas Department of Public Safety? Yes, they were. And again, what happens if the 2 breath samples are not within the allowed tolerance?
So if the 2 breath samples are not within the allowed tolerance of 0.02, then the instrument will flag an incomplete test with an exception message stating no subject 0.02 agreement.
During the course of your training, did you learn about the effects of alcohol upon a person's mental and physical faculties?
Yes, I did.
Based on your training and experience, how can alcohol affect a person's mental faculties?
So mentally, one of the first things impacted is an individual's judgment. Next, things affected would be in individuals' inhibitions. They might start doing things they wouldn't normally do. The perception, they might start seeing things happening around them that might not necessarily be exactly how they're occurring. Then an individual's vision can be impacted. This can result in blurry or double vision, and especially in individuals' tracking ability, so the ability to follow objects from side to side, either while they're driving or walking.
And based on your training experience, have you or yourself conducted or participated in any experience on the effects of alcohol on a person's mental and physical faculties?
Yes, I
have. And based upon your studies and your own experience, do you have a personal opinion as to the alcohol concentration at which a person does not have the normal use of his or her mental or physical faculties?
Yes, and I would say that would be 0.08, with some individuals displaying signs of intoxication at lower concentrations as well.
Why do you hold that?
I hold that opinion based off of research as well as dosing operators at operator school, as well as myself being dosed at operator school, and just from personal experience as well.
And in your opinion, would a person with an alcohol concentration of 0.153 or 0.160 have lost the normal use of his or her mental or physical faculties?
Hold on. I'm going to object, Your Honor. I don't believe this witness has been established as an expert, so we hope not provide an opinion.
Really? Response?
Your Honor, based on the witness's educational background that he provided, his training and experience which he provided, the extensive training that he provided, it.
Yeah, I'm going to overrule the objection. Sorry. Okay.
In your opinion, would a person with an alcohol concentration of 0.153 or 0.160 have lost the normal use of his or her mental or physical faculties?
Yes.
And why do you hold that opinion?
I hold that opinion based off of my training, personal experience, and as well as research as well.
And there's two subject results. Why are there two numbers?
That is because each individual that has the test administered on them, they provide 2 breath samples. Usually in terms of calculations, we typically will go with the lowest of the 2 to give the benefit of the doubt to the subject.
Are the subject's test results a representation of his or her alcohol concentration at the time of the test or at the time of driving?
At the time of the test.
Is it possible to determine a person's alcohol concentration at the time of driving?
Yes, it could be, as long as specific facts are provided, and that would be referred to as a retrograde extrapolation.
Can you explain that process for the jury?
Sure. So it entails with specific facts such as the time of last drink, time of last meal, time of stop, as well as a concentration that an individual blew at a time of test. It is possible to determine what an individual's alcohol concentration would have been at a previous point in time, such as the time of stop or time of incident or time of driving, all kind of referring to the same thing here.
And what is absorption?
Absorption is the process of ingesting alcohol, usually through the form of drinking it, and then it being absorbed into the body, largely through the small intestine.
And what is elimination?
Elimination is the body's process of eliminating alcohol from the body. Alcohol is metabolized and broken down by the liver, but it is also eliminated through breath, sweat, and urine. With the breath elimination being the basis for which a breath sample is provided and analyzed through the intoxilizer.
Given the facts in this case, were you able to extrapolate?
I would need to know those facts before being able to.
State passes the witness, Your Honor.
Okay. Mayor, Your Honor?
Yeah.
All right, Mr. Cooper, is it Dr. Cooper?
Just Mr. Cooper.
I don't want to be disrespectful.
Oh, no, you're fine.
Okay, so your state just finished up their questioning with extrapolation, is that correct?
Yes.
Okay, so you would need a specific set of facts to make that determination, correct?
Correct.
And if you don't have the specific set of facts, you cannot extrapolate that, is that correct?
That is correct.
So again, the 0.153, 0.160, that's at the time he blew, but not necessarily at the time he was driving, correct?
Correct.
Now, you talked about the 15-minute waiting period. What was the, or what's the importance of that 15-minute waiting period?
It's to ensure that there's no residual amount of alcohol in an individual's breath that could be leading to a false elevation of the test reading, such as if you were to take a shot of liquor and then immediately blow into the instrument, the excess alcohol in your mouth would read exceedingly higher than what your actual blood concentrations.
Okay, and if the 15-minute period is not observed, would that be a problem?
If it was not properly observed, it would be a breach in our procedures.
And in your training and experience, you indicated that somebody with .153 could have lost their judgment, and inhibitions, things like that, correct?
Correct.
Also in your training and experience, is it possible for somebody to be below .153 and not have lost all of their faculties?
As far as what concentration?
We don't know, but let's say if they're below, because you talk about the body absorbing, right?
Correct.
So your body has to absorb alcohol first, correct? Before it can eliminate?
Yes.
And that's a process that takes some time, correct?
Elimination begins at the same moment that absorption would begin.
Okay. But that doesn't happen like immediately. Like you don't take a shot and it immediately starts absorbing and eliminating, correct?
A small amount is absorbed in the mouth and the stomach lining, with the majority being in the small intestine.
Okay, but in the mouth and stomach lining, that would not register on this machine, correct?
It depends on how much is absorbed. I would assume that it would not lead to a very high reading at all.
Okay. So again, if somebody was below this amount, would they lose their mental and physical faculties? Or would it depend on their tolerance?
I would say that all mental faculties are for sure lost at a 0.08. Tolerance that an individual has displayed could affect the outward signs of their physical faculties being impaired.
Okay, so you're saying all mental faculties would be lost?
At a 0.08, yes.
Okay, so a mental faculty would be the ability to drive a vehicle, correct?
Yes, I would say that is utilized in that.
Okay, so if somebody's still able to drive a vehicle, based on what you just said, that means they would be below a 0.08, correct?
I would say the ability to drive is largely impacted by how well they're driving, impaired versus not impaired.
Okay. So you would expect to see swerving?
Potentially.
You would expect to see maybe an accident?
That could be a possibility, yes.
Okay. You would expect to see possibly erratic driving kind of all over the road, maybe hitting another car or coming close to hitting another car, things like that?
That could be a possibility as well, yes.
Okay. What about speeding?
Yes, I would say that could be an indication as well.
Okay, but have you ever received a speeding ticket?
Yes, I have.
And were you intoxicated when you received that speeding ticket?
No, I was not.
So it's possible to speed even though you have all of your mental faculties, correct?
That is correct.
So speeding is not by itself indicative of intoxicated driving, correct?
No, it could be still a sign of intoxication.
Would you expect to see others?
Potentially.
Now, are you familiar with the standard field sobriety tests?
I am roughly familiar with them, yes.
So you're not certified in them, correct?
No, I am not.
Now, this machine you said was last tested on 9/23/24, correct?
Before the subject test, yes.
And you said that the operator at that point forgot to plug in a tank, is that correct?
Nikithia Rogers, she forgot to plug in the simulator communication cable, which is what connects the simulator to the Breathalyzer.
Was that the case when this breath test was taken?
No, that was during her QA inspection.
All right, so just to be clear, these results are at the time of the breath test, correct?
Correct.
And without additional facts, you cannot determine what his alcohol level was at the time of driving, correct?
Correct.
Nothing further, Rich. Okay.
Anything further, State?
Judge, move, Coach.
Sure. Scoot on. I don't believe. I don't. Yeah, that's something that you said that. The information. Nobody has done. Stand the top training. Well, he testified that there was one that was like, there was different testimony as to the right. So, yeah, I mean, what are you trying to do? How? Not through him.
No, not through him. It would have to be prior, but
You can't use him.
no, I can use him.
Right. Okay, let's continue. Okay, thank you. So State, do you have anything further?
Yes, Your Honor.
Okay. Make it brief.
Outside the .08 number, are there other factors to be considered when determining if an individual is intoxicated?
In regards to mental and physical faculties,
Yes.
some individuals could display signs of intoxication even after their first drink of alcohol. Tolerance also plays a factor as well. But tolerance is only the outward display of being able to mask your physical signs of intoxication, and it has no impact on your mental signs of intoxication.
So it is just one specific thing that tells you whether an individual is intoxicated or not.
I'm not really sure what you're asking.
Do you evaluate multiple factors when making your analysis?
I'm gonna object, Judge. I don't know exactly what he's asking. If there's multiple factors as to this breath test,
He's right.
Yes, Your Honor. I'll rephrase.
Okay.
I'll move on.
Okay.
Was everything for this breath test done in accordance with standard policy? Procedures?
As far as what I've observed on the breath records, yes.
Nothing further than stated.
Okay. All right. You may step down.
Thank you.
State, do you have any further witnesses?
No, Your Honor.
Okay, so you rest.
Yes, Your Honor.
Okay.
I'll have a motion, Judge.
Okay, so hold on. Can you take the jury out for 1 second? But don't take them far. Yeah, but just don't take them far.
All right, for the jury.
Okay, please be seated.
You found right out the door, there's gonna be drugs.
Sure, of course. For what it's worth, I don't think they can hear anything, but absolutely. Yeah. Of course.
Sorry.
Absolutely.
And so Judge, I'd be asking for a motion for the directed verdict. I believe this state has failed to meet its burden beyond a reasonable doubt. First and foremost, they never established whether or not he was operating a motor vehicle. They identified the type of vehicle, but they didn't ask any witnesses if it was a motor vehicle. And that was never established. That's the first part. Second part, I don't believe they've established intoxication beyond a reasonable doubt. They never asked any of their witnesses if the person had lost the mental or physical faculties. All they did was go through the field sobriety tests and indicate what the results of the field sobriety tests were. But none of the witnesses indicated whether or not they had lost their mental or physical faculties. And on top of that, finally, Judge, with this witness, the breath test, he was able to establish that the breath test was done at the time that was his blood alcohol concentration at the time of the test, not at the time of driving. Without any additional information, there's no indication what his blood alcohol was at the time of driving. So therefore, I don't believe they've established their burden as one, as to a motor vehicle, two, which the complaint or the information says, operated a motor vehicle in a public place in Harris County, Texas. And then also as far as the intoxicated portion, like I said, no testimony as to loss of mental or physical faculties, and no indication that he was at a 0.08 or higher at the time he was driving. So that's why I directed verdict at this time, as the state has failed to meet its burden.
Your Honor, I'll try and go in order here. The facts clearly show that it was a motor vehicle, made it simply because I didn't ask for a conclusory statement from the witness, but demonstrated that the defendant was in fact driving a motor vehicle by the facts that were given. The officer testified that the defendant was the driver of the vehicle. There was no one else in the vehicle, that he witnessed the vehicle the entire time from when he first went into.
Yeah, stop. I disagree. I think that there's enough to go forward. I do. I think they testified to it that, we asked them the ultimate question. So, I think that there's enough to go forward.
But my understanding, Judge, is that the state has to meet each and every one of their elements beyond a reasonable doubt. One of the elements is a motor vehicle, and that was not established beyond a reasonable doubt at all.
He testified that he pulled him over.
Correct, Judge, but it could have been a go-kart. It could have been anything.
He's on video in a car.
Your Honor, the state still has to
No.
establish.
I disagree. I think that they've met it. Let's go from
Good. We can complete, Your Honor.
No, I've got a jury coming in. Give me 5 minutes. You wanna? I get. No, and then.
All right, for the jury.
Now, and then we'll do the charges.
Okay.
I'm gonna invest and.
Okay.
All right, everybody, please be seated. Okay, so you have rested. Defense, do you have any witnesses?
We do not have any witnesses, Your Honor.
Okay, so defense rests. Okay, so now we have some business matters to attend to prior to closing. So what I'm gonna do is I'm gonna feed you guys now. I know that you're probably pretty hungry, so I have lunch for you now. We're gonna try to, like I said, be as efficient as possible. So eat. I'm gonna bring you back probably 15 minutes, so we can just get started and keep moving, okay? We're close though, all right? Please.
All right, for the jury.
Okay, be seated. You can take him back for now while we get everything ready. Should we do the charge?
The little printed, you want to take a plea and then.
Yeah. Okay, all right, Michael, you ready? Okay, the reading?
Judge Mayor,
No.
here's something.
Yeah. We're printing a charge for you. Is that okay?
I want to ask for specific instruction. I want to put the case law for that instruction.
Which,
3823.
I'll give it to you.
Okay.
Yeah, don't worry. I'm gonna give it to you. Just, do you have one for me?
A case law?
Let me hold it.
Or- Oh, no.
Ramona.
You have a 3821.
No, it's trying to eat. Take a trial for a life.
Hey. Oh, so. Thanks. No. You can stay. Yeah, so you're not. I just. Give me 2 seconds. 2 seconds. Okay.
All right, Mike.
Yes, right. Miss Darcy Davis.
You're probably hungry too.
I know, I'm not done. I got the family corner.
How do you do it?
Thank you so very much for being patient. I really appreciate it.
Yeah. Yes, sir.
Thank you for coming. Thank you. Okay, so Ms. Davis, I guess you've had all the discussions, decisions, you know what you're doing. We've given you sufficient amount of time. You've now accepting this agreement where they've charged you with assault. You are pleading guilty to this offense. It's going to go on your record. It will be there for the rest of your life. You can never take it off. Like I said, from now on, you pick up any cases, you're likely to be looking at a minimum of 90 days in jail. You understand? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. Is this what you want to do?
Yes, sir.
How do you plead to the offense of assault?
We'll see, sir.
I'm going to find you guilty. I'm going to sentence you to 3 days in jail, give you credit for the 1 day that you've done. I'm going to roll your court costs so you won't owe anything, and good luck to you.
Thank you.
Thank you, Mike. Okay.
Thank you.
Yes, ma'am.
That's a bad one of that.
No one else aside other than him, right?
Yeah, we don't have, he's all.
Okay.
The last one that we have.
Oh, we still have someone else.
Told Victoria, she said they used to file something for her.
That's Moreno? Rodriguez. I don't even know.
It's a collection. It's the last one. Did you get lost? Got a question with the session?
Are you Brianna?
Yes, you do.
Maybe a supervision order.
No, you don't say anything.
Oh.
No, I'm standing here. You already signed it. I did.
Okay.
So you're just gonna take that down, go to the floor, and be a glass room across the hall from the cafeteria. You just send that to one of the ladies and they'll clear your court costs, okay?
Okay.
All right, you got.
What's that? I know. You know, it's interesting, French trial. Thank you. Have a good one. I didn't really have to Oh, no. I'm sure I can come back. I said we still do it. Sorry, thank you.
That's my.
Am I still?
I mean, I can't sign anything.
I know, it's.
I can't even sign this PR.
Do entries and push stuff in your queue, but it's like everything is slow. On one side, it's.
Vic.
This is what I'm doing. This is also the sort of the added to, I think this is what happened during the other most common. Here.
Our system is down. That enables us to sign stuff, and it's been down for like 45 minutes. So that's why I've not been able to sign your PR bond. I still can't sign it. That's what I'm waiting on.
Yes, Judge.
Yeah, Vic, Deeds is completely down. I can't sign anything.
Yes, Judge. It's been down for a minute. They've already submitted a ticket. So we're just waiting.
Do another damn ticket, man.
Will do.
All right, I just found that this was on.
Issue a warrant.
I'll do one on you.
They already got Justin Harris.
Do you want to print it out? I can sign it. Maybe you can do that.
The PR bonds are ones that we have to like, that's like a free trial thing, but I have to do runs. So it's better if we get it online because it virtually just goes over there. I'm not sure how comfortable they are. So what I do, you see. Sheesh. How you want to look this way, you want to type it open together? Let's type it open. Yeah, it's already for the Shreya approached on for the admin.
Oh, I need to undo that.
So we're not going to edit that.
I want to sign it as I'm denying it.
Okay, yeah, it's already signed. I can just check the boxes denied.
Check denied. I'm denying the withdrawal. That way they could take it back. There was actually literally a limit right here trying to get it.
Gotcha. This is the illustrator taking let me just, I don't think anything's on here. Let me just make sure. I don't know if it's anymore. I guess I can shoot that the whole thing. Yeah, I think the whole thing. You know how to do that? Yeah, no, I never did it. I don't know. I wonder if I'm getting straight. Yeah, you're proposed cherry, sure. We're just working on it. Whether they instruct the 38.3 instruction you want, yeah, that's just our practice.
Yes. So I'm following this.
Okay, Vic?
Yes, Judge, you ready?
Who's first?
Page 7, Chan, set for arraignment failed to appear, first time.
2501.
Page 18, Coleman, set for arraignment, 2 bonds posted, failed to appear.
Uh, 5002.
BO?
Yep.
Okay, let me know when you're
If I
ready for
can.
this. Oh, that's right. I'll remind you. Do you want to move to the next one?
Yeah.
Because I don't think it's up yet.
Okay.
Next one is page 22, Maness, set for arraignment, failed to appear, first time.
The bond is at 101. That's really weird. That means she's failed to appear.
Well, it's only 8 days old. Maybe it's a typo?
No, it's from 22. This is from 11, 28, 22. Let me see.
Oh, yes, Judge. 2 bonds posted, a GOB and a PR bond.
When was the GOB done?
March, let's see. September of 2022.
Huh. I'm not even seeing that.
Yeah, deeds is going slow.
Okay, so
Oh.
5002.
Okay, 5002.
Give me a second. I can do a BO on this if you could just give me 1 second because they're pulling up.
No, Judge, hang on. My screens are delayed because deeds is not acting right. So for Maness, on page 22, for sure, there was only 1 out-of-county bond posted. It was a non-arrest for a while.
So just do 2501 then.
Okay. Next is page 27, Parks. She checked in and left.
Okay, 5002.
Okay,
And let me try to do a mailer real quick.
okay.
Got it, okay.
Yeah, this three copies, yeah.
I think,
Is yours one?
yeah, I think buildings with state law conditions, yeah, state law conditions.
No.
Is it? Okay.
Yeah, it's a DWI. So he's got this. Okay, parks.
This article regarding. Yeah. With the body. Yeah.
No, she really wants to see, her time period. Zero out. Expect anything different from that going into this? Oh, no, shouldn't, no. I don't have to tell you the office.
And can y'all look at this to make sure it's what you want?
Sorry, not sure. Thank you. Not sure. I was like, are you serious? I'm giving that. Those are exactly better.
Can you go there? I don't know. I'll let you.
Judge, you have a very important phone call.
I just go.
Club? Who? Okay, well, you want to reach out to him? I can let him do it through Zoom. Bye. Ma'am, I just issued a warrant for your arrest. Yeah, you come whenever you want to come. You don't come when you're required to come. I told you to be here at 8:30 today. You arrive at what time? Or, okay, 9. You came in. Do you see her have her check in? I know she's here now, but she got here when I looked over there. It was like 12. Right. You were set for trial yesterday. You appeared at 1 p.m. Just, you're not allowed to leave. We're trying to find your lawyer. All right, guys, what'd you say about the charge?
We're still going through it. It's
Yeah.
really long. It's really long.
Imagine a felony case. Like 80 pages.
I think my last one was 10.
In a felony case? That's short. Those capital cases, man.
Oh, no, yeah, that's a whole nother
It's a
one,
book.
not just a PCL.
I'll give you the copy. I'll print you a copy, just let me figure out what they have is the, it'll be right back.
Yeah, we're going to start soon.
Yes, sir.
Yeah.
I will be, but.
Is that the one, that's when you had downloaded? Yep. And then you could jump.
Yeah, I think it's okay. Vic, was there anyone else that you wanted to go through?
Hey, Judge, I just talked to Josh and he said he would rather go over the plea papers with her in person.
Okay, so we'll roll it to tomorrow.
Okay, I'll let him know for tomorrow.
Call the warrant.
Yes, there was one more on page 35. Worrell. Jessica, set for arraignment, failed to appear first time.
2501. We need her to sign a reset though, if you don't mind. If you don't mind coming out so we can have her sign a reset.
Yes, Judge, I'll come out in just a second. I have one more to go over with you. Page 37. Zimmerman was set for arraignment yesterday. We rolled it for today. I did reach out to counsel multiple times via email and called. And
No,
no
I didn't talk to her
response.
about this.
Yeah.
What do you want me to do? Did this person show up?
No, Judge, and you reinstated and gave him a week to get here.
Okay, 5002.
Okay.
All right.
Okay, I'm coming out.
Meetings.
So Don told me that the office.
Right, so you didn't, still alive at every time.
So it was. Yeah, because I mean, I was object to just this, that I'm going to drop.
Pictures.
Which
French drop this off for you.
Finn. What? Okay. Guys, you have an objection?
Yes, Judge.
Tell me.
The state's gonna object to the 3823 objection, Your Honor.
Okay.
And the basis for the objection is that I'm gonna say that we, the state and defense, are not in disagreement to the factual basis of the stop. John told me that on direct examination, the officer testified that he ran the defendant's registration and observed that it was expired. Defense did not contest that on cross-examination. So I'd argue that the state and defense are in agreement as to the basis of the stop.
I did contest it, Judge. I asked him, I said, what you perceived was speeding.
Tested both.
Correct.
Yeah.
You perceived the speeding led you to running his plate, correct? Yes, I said, but if you hadn't perceived him as speeding, you would have not run his
I
plate,
mean, he
correct?
contested damn near everything. He did.
Okay. Judge,
I'm gonna overrule your objection. I'm gonna allow it.
I understood the court's made its ruling. I would like to have that language reflected in the jury charge of those two areas for the basis of the traffic stop. The speeding and the expired registration, Your Honor.
Ray?
Judge, I think that the speeding, I think it's fruit of the poisonous tree. When you go into the, are we on the record? When you get into the speed. When you get into the speeding aspect of it, again, the officer testified that if he hadn't perceived him to be speeding, he would have never run his plate. So therefore, I think that just the speeding alone is sufficient to say he didn't have probable cause to do either one. Either he didn't have probable cause to.
So why do you have a problem if they put both? You know?
Because I believe it would be misleading to the jury because I'm really contesting the reasoning behind it, the speeding. And then after he perceived the speeding, then is when he ran the plate. It's not that he pulls up next to him that he runs the plate. So I believe, but for the speeding, the plate would have never been run. And even the officer testified to that because I asked him, you were going the opposite direction, correct? So I think realistically, the biggest contested matter of fact is the speeding, which led to everything.
Okay.
So I believe a 3823 instruction with the speeding is appropriate.
And I do have a response, Judge.
Sure.
So yes, defense has mentioned that it's fruit of the poisonous tree. I don't see any indication of how getting behind a vehicle that he thinks is speeding is any sort of search or any sort of privacy interest that exists in that mere fact alone. While he was
contesting the stop.
He's contesting the stop. Yes, correct, Judge. And if I may counsel, if there's two bases for the stop, then that should be reflected in the jury charge.
What's the 3823 just on the speeding?
Just on the speeding.
Am I right?
That's correct.
Okay, so I'm gonna give you just that, what you're asking for, right?
Judge, I believe the way it's currently reflected in the instruction would be misleading to the jury because it says, before you may consider the evidence obtained as a result of Officer Medder's stop and detention, you must all agree that the state has proven beyond all reasonable doubt that Officer Medder reasonably believed that the defendant was speeding before Officer Medder stopped him. The state's arguing that it's not that he has to show that he was speeding and that's why he stopped him. The state's arguing that that's misleading because he can get behind him even if he thinks he's speeding. And then if he happens to run the registration before he initiates the traffic stop, which he did in this case, and it was expired, that is sufficient for reasonable suspicion and probable cause to initiate the traffic stop on its face. The way this instruction is currently written, Judge, it's asking like, well, if he wasn't speeding, then you suppress all evidence.
That is correct, Judge.
I mean, I think I agree with that too, because they do, if he wants to run the plate just because he wants to run it, he can do that. There's no law that prevents him from doing that.
Correct, Your Honor. And I can see that argument, which is why I specifically asked him, if you hadn't perceived my client to be speeding, would you have ever run his plate? And he said, well, I can run plates whenever. I said, in this particular instance, would you have ever run his plate? And I believe he said no. So if the court recalls on dash cam.
I understand it. I get it.
If my client had just crawled through the intersection, he would have, Officer Medder would have continued straight. He was going to go straight.
How do we appease both of you in this situation?
Judge, let me tell you how this can happen. In the second paragraph on page 5 of the jury charge, it says you may consider this evidence, referring to the evidence that comes from.
Wait, where are you?
I'm on page 5 of the jury charge.
There's no provision number, so.
Oh, sorry. It is under disregard evidence if unlawfully obtained. The second paragraph is just one sentence, Your Honor. You may consider this evidence only if you resolve a preliminary question in favor of the state. It then goes on to say that you need to address the issue of if they're speeding. That is going to inform the jury that they need to only consider the speeding and just disregard the other lawful basis of the stop.
You're talking about the third paragraph?
The second.
No, it's where it says, before you consider evidence obtained as a result of officer Mike Commander stop, you must all agree that the state has proven beyond a reasonable doubt the officer reasonably believed that O'Dear was speeding before Mike Commander stopped him, right? So, but there are other ways, right? Because he used in his testimony 2 ways. He also said that I did both. You know, it's fair.
I can see that argument, Judge, but my position is still the same.
I get it. So how do we put that in the language?
Judge, the easiest way to do that would be to say that I'm looking at the bottom paragraph of that page, Your Honor. You must all agree that the state has proven beyond a reasonable doubt that Officer Mike Commander reasonably believed that the defendant was speeding or had expired registration.
Right?
I would still object for the same reason, Judge. I believe that the expired registration is.
Okay,
for the
I guess I'm going to
closest
overrule your objection because we'll just put or registration, you know? I mean, unless you have a better wording for it.
And or?
And or. Are you happy with that? Yeah, because it's and or. It could be or. It could be both.
Sure.
Yes. Are you happy with that?
That's fine.
Okay, done. So just put and or, and then after that, no objections from the state?
I saw, no, never mind.
Just a moment, Judge. I haven't read the last page here of the jury charge. Separated and, yeah.
I think it's been 1, 2 should be typical now, 3 should be. That's how I perceive.
I do think that, yeah, it's been a minute since I've seen it.
I haven't.
I do think it would make it more clear to the jury if you have one mental faculties, 2, or physical faculties, 3 to point of right.
Are you saying this should be found?
Yeah, they can, right, like 1, 2. And then.
Oh, you decided to do it that way anyway?
Yeah, it's back up.
Yeah, it's back up. Okay, not a problem.
Yeah, I don't have to go to JPC.
See, this, you put this, put.
Yeah, no, absolutely. All right, I'm signing it for you.
I mean, I don't know. That doesn't bother me one way or the other.
Is there another issue?
I don't think it's a huge problem, but if the state wants to address it, I have no problem fixing it.
I agree with defense judge. I don't see it's much of an issue. It's just that on the page.
On the definition of intoxication, Judge.
What about it?
I think, I would like to. Okay, yeah. Yeah. We would just like to clarify that to number it as 1, 2, and 3, 1 being not having the normal use of mental faculties, 2 being not having the normal use
Yeah,
of
no, that's
physical.
right. It's got to be 1, 2, and 3. Right. Yeah. That's okay.
All right.
Yeah.
I have no issues with that, Judge.
Okay. So we'll fix those and then no objection. We get them in here. Yeah. All right.
No objections, Judge.
So now you have it.
So it should be 1, and.
Okay. Is it in mine or is it in there? Okay, I'll sign
But I think it's at the top of your queue right there.
Got it.
Oh, okay, I see what you're saying.
These just.
Give them paragraphs instead of just having them one big paragraph.
Correct.
Okay.
All right, cool. Thanks.
Nice.
That's also.
I think so. Yeah. But it's stop. That's so it's actually because of, yeah. What would it be times 3? So we don't see many clients in here. Yeah. And he's got everything. I mean, yeah. Well, I mean, I'm voting on this. I mean,
That's the part of the world.
Well, they come back on the next.
Yeah, that's out.
You didn't ask my best converters.
Setting structures and then, yeah. But there's no.
Oh, yeah, there is.
So, if they think about these things, like, so you didn't have to put it.
It's better than cool.
Well, it's, yeah.
So you guys started with 100 and we go with the other way. Yes, people.
Yeah.
On the same line, I sort of.
I'll give it a try. I don't know.
You go on and start it out. Yeah, like, differences in that.
That's so fast.
I will. I'm just telling you.
So I can like pass by on just so they get to me. So now if anything happens, if you know who did it. Was that like I have to?
I'm gonna keep another wing there. My tree, by the way,
Okay, well, I'll
You think I'm serious?
When our meeting.
I'm not serious.
He's gonna be a lot.
I don't know. I mean, I have to do this song. I have to have. It also plays with here for the trial stuff like the on.
Yeah.
Where you go? He had to go with his kid. He had to get picked up from school. I don't know if it was like he was sick or something, but he should be back.
Yeah.
What? When you fall that shit? It's over there. So you should know what kind of sense that is.
Sorry, two of my license. Oh, I just said one.
What you said, I keep your understand how long that's somebody come out. Because we're trying to get it.
I realize it was two though.
Yeah, I don't know.
Well, I'll say this, I'll write it on. Yeah. I know that.
All right, relative. Want to see it later? Just for, make sure that you're okay.
Yes, thank you, Judge.
Right. You judge. Can you take a look just to make sure you're there? I'm just not worried about it. That's okay. Yes.
Thank you.
Tony Romo.
Yes, sir. Judge, did you hear Santana back to it?
No.
Well, he didn't die. He passed out on the stage and they took him to the hospital. No, I'm sorry, that was me.
She killing people all the
Yeah. Keith Richard. Oh my goodness, yeah. I said he passed away, I passed out. I meant passed out, not passed away. I'm so upset about the whole thing. You know what's even sadder is that people, and I want to know like that.
Yeah, that is pretty sad.
Okay, guys, what say you? You okay?
Yes, Judge, just I put something here on the intoxication definition. On the definition for mental faculties, I'm showing that faculty is missing. It reads, one, not having the normal use of mental by the reason of introduction. And then also.
Yeah, okay.
On.
Which one?
Right here.
Oh, mental state. Okay, well, because that's not for them.
It's because you had it as an or before and it was
Yeah.
afterwards, so
Yeah.
you just, yeah, it just needs to go in there. So here I wrote.
Anything else?
And as well as the language for physical faculties, not having
I see what
the
you're saying.
normal use of physical faculties as well. Because it just goes right.
Mental faculties and then physical faculties.
Yes, as well as.
Not having the normal, so paragraphs 1 and 2 should read exactly the same except for normal and physical. One should be normal, I'm sorry. Mental, thank you. And one should be physical, but they should be exactly the same, yeah, except for mental and physical.
Anything else?
I completely missed the less than 0.15 up there earlier, so. All of a sudden, already. While we're here, the state and I have, if we want to talk about it so we can move stuff along. State and I have come to an agreement that if he's found guilty, we'll stipulate to the first and do a time served on it.
Yeah, I think he's probably got enough.
Yeah, he's got 73 days credit, so he's
I'm with
got,
you. I was gonna time serve him regardless. Yeah.
Stipulate to, wait.
Yeah, I was with you.
we'll
Oh, stipulate to the prior.
stipulate to the prior, which
Gotcha.
makes it a second.
Great.
And then that gets you above the 100, even if they come back, well, I guess, if they come back
I
at
was gonna do time serve regardless because I know he's got a lot of back time.
Yeah, he's
So
got 70-some days straight. Cool. So regardless of what it is, we'll
just
just,
do 100 credit for 7, or what do you want to do?
he's got 73, you said?
I think-
How many days does he have? Sorry.
I think that's right.
I mean, I'm hoping for the 2 work.
I get it. Well, no, but let's be prepared
Right.
for the eventuality.
Yes,
If it does. Yeah, 73. So I don't,
It's 219.
So let's do like 210, just to make it clean.
210, yeah.
so that if it's, then that's
Just to make it clean.
Yeah, it's good.
And then I've already explained to him and his family, I'm like, regardless of what the verdict is, you're going uptown or up north. Oh, yeah.
Hey, did Charlotte see it? So not having a normal use of mental faculties, trying to make normal use of physical faculty. Is that it?
Yes.
Correct. Yeah, you still have, you'll have a better shot of finding it.
yeah, just make sure you guys are ready. We'll bring them in.
Yes, I don't know if, I don't, we saw the final, okay, he's gonna have a point.
Oh, Tony, you want to use this one? Okay.
Yeah, that one was.
Thank you, exactly. Perfect.
Guys, you ready?
Yeah.
Okay. Let's go. No, they should be done. They've been even like for at least an hour. Yeah. So 20 minutes, guys? 20 minutes?
It's good, Judge.
All right, for the jury.
All right, please be seated. Okay, filet and lobster good? Okay, members of the jury. The defendant, Odir Alberto Game Santa Maria, stands charged by information with the offense of driving while intoxicated in Harris County on or about October 6, 2024. To this charge, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will receive a written copy of these instructions to take with you and to use during your deliberations. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will receive a written copy of these instructions to take and use during your deliberations. First, I will give you some general principles of law that you must follow when deciding this case. Then I will instruct you on rules that control your deliberations. Finally, I will tell you about the specific law that applies to this case. The information. The information is not evidence of guilt. It is the name of a document required to bring the case before you. The information cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, or otherwise charged. You may not draw inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his or her innocence or to produce any evidence at all. Unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt of for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it is not required that the state proves the defendant's guilt beyond all possible doubt, it is required that the state's proof exclude any and all reasonable doubt concerning the defendant's guilt. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If after you've considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not in evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not in evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of testimony of the witnesses and materials admitted into evidence. Nothing I have said or done in this case should be considered by you as an opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings. Ready? Do you mean to go back?
Meanings.
Okay. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meaning provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. Admitted exhibits. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. You must follow these rules to request that testimony be read back to you. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson, 1, states that it is requesting the testimony be read back, 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute, and 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The verdict. The law requires you to render a verdict of either guilty or not guilty. A verdict of not guilty simply means that the state's evidence does not prove the defendant's guilt beyond a reasonable doubt. You may return a verdict only if all 6 of you agree on a verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify.
We go about 30 seconds back, Judge.
Sure.
Sorry.
You want to go back from the verdict?
When you return a verdict, only if all 6 of you agree.
Okay. So you may return, Tony, you ready?
Yes.
Yeah, okay. You may return a verdict only if all 6 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him and is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had testified or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. These are the rules that control your deliberation. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick a foreperson. The foreperson will preside over your deliberations and conduct them in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves, then you must stop your discussions about the case until all of you are present again. You must communicate with me only in writing signed by the foreperson and given to me through the officer that is assigned to you. You must not conduct any independent investigations, research, or experiments. Number 5, you must tell me if anyone attempts to contact you about the case before you reach a verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. After you've arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. disregarding evidence if unlawfully obtained. You have heard evidence obtained as a result of a traffic stop and detention of Odier Alberto Gomez Santamaria by Officer Micah Metter. Specifically, you have heard the testimony of Officer Micah Metter and other state's witnesses, as well as evidence of a breath test suggesting that Odier Alberto Gomez Santamaria might have been operating a vehicle while intoxicated. You may consider this evidence only if you resolve a preliminary question in favor of the state. No evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America shall be used against the accused on the trial of any criminal case. The state must therefore prove beyond a reasonable doubt that the evidence was not obtained in violation of the law. A police officer may, under the law, stop and detain a motorist without a warrant when the officer has reasonable suspicion that the motorist has committed a criminal offense, including a traffic offense. Before you may consider the evidence obtained as a result of Officer Micah Metter's stop and detention of Odier Alberto Gomez Santamaria, you must all agree that the state has proven beyond a reasonable doubt that Officer Micah Metter reasonably believed that Odier Alberto Gomez Santamaria was speeding and or had expired registration before Officer Micah Metter stopped him. If you find that beyond a reasonable doubt, then you may consider all of the evidence obtained as a result of Officer Micah Metter's stop and detention of the defendant. If you do not find that fact beyond a reasonable doubt, then you will disregard all evidence obtained as a result of Officer Micah Metter's stop and detention of the defendant, and you will find Odier Alberto Gomez Santamaria not guilty. The law on driving while intoxicated. You are instructed that a person commits the offense of Class B driving while intoxicated if the person is intoxicated while operating a motor vehicle in a public place. In this regard, public place means any place to which the public or substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospital, apartment houses, office buildings, transport facilities, and shops. Motor vehicle means a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device used exclusively on stationary rails or tracks. Intoxicated means, number one, not having the normal use of mental faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of those substances, or any other substance into the body. Two, not having the normal use of physical faculties by the reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of those substances, or any other substance into the body. Or three, having an alcohol concentration of 0.08 or above or more. Alcohol concentration means the number of grams of alcohol per 210 liters of breath. You are further instructed that if it is shown during the trial that an analysis of the specimen of the person's breath showed an alcohol concentration level of 0.15 or more at the time of the analysis was performed, then the person has committed the offense of Class A, driving while intoxicated. Or you are instructed that if you believe beyond a reasonable doubt that Odier Alberto Gomez Santamaria breath showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, you will find the defendant guilty of the offense of DWI misdemeanor 0.15 or greater and say so by your verdict. But if you do not so believe, or if you have a reasonable doubt thereof, you will proceed to consider whether the defendant is guilty of the lesser offense of DWI misdemeanor Class B. Class A, driving while intoxicated. Now, therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Odir Alberto Gomez Santamaria, on or about October 6, 2024 in Harris County, Texas, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, and you further believe from the evidence beyond a reasonable doubt that an analysis of Odir Alberto Gomez Santamaria's breath showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, then you will stop your deliberations and find the defendant guilty of Class A driving while intoxicated. If you do not so believe, or if you have a reasonable doubt thereof, then you will consider whether the defendant has been proven guilty of Class B driving while intoxicated as instructed below. Now, therefore, if you believe from the evidence beyond a reasonable doubt that defendant Odir Alberto Gomez Santamaria on or about October 6, 2024 in Harris County, Texas, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, then you will find the defendant guilty of Class B driving while intoxicated. If you do not so believe, or if you have a reasonable doubt thereof, then you will find the defendant not guilty. I've now signed the verdict sheet. Each side will get 20 minutes for closing statement.
Thank you, Your Honor. The state waives its opening and reserves its time for closing evidence.
Okay. Defense, you may start.
May I proceed, Your Honor?
Please.
I told you at the beginning of this case, in my opening, of the things you would not hear. I told you would not hear what his exact speed was. And I told you would not hear what his blood alcohol content was at the time he was driving. Out of all 4 witnesses that the state has put on, not a single one of them could say that with absolute certainty. Nobody can tell you either one of those facts. You heard from the analyst who said that he would need specific facts to determine what his alcohol level was at the time. He talked about absorption, how alcohol enters the body, how it takes some time for the alcohol to enter the body. And when asked, can you do that in this case? I believe the state asked him that. He couldn't. So we don't know what his blood alcohol content was at the time of driving. We know what they claim it was, or what the sheet shows it was at the time that he blew. That doesn't mean that's what it was when he was driving, right? Then he talked about the mental faculties and physical faculties. And the analyst told you that he believes somebody with a 0.08 loses all faculties, right? And I asked him, does that include driving? He said, yes, I believe it includes driving. I said, would you expect to see other driving patterns? Would you expect to see swerving? Yes. Would you expect to see an accident? Yes. None of that happened here. It was supposedly speeding was the only issue, right? Now let's talk about the speeding. Officer Metter found northbound on Southwest. He says he knows that intersection well because the station is not far from there. And he knows how fast somebody's going because of the flow of traffic that goes through there. There was not a single car on that road, not one. He admitted, my client had the green light. He didn't run a red light. In fact, we see him stop at the appropriate place at the next intersection. So it doesn't run a red light. There's no traffic to compare his speed to. Metter waits 10 seconds before even pulling out, or 8 seconds before even pulling out to go after him. And then when he does go after him, he claims he hit 64. He says that you can see that on the video. We didn't see that on the video. There's nowhere on that video does it show what his speed was. Why? Because we don't know what his speed was. That's just what he said it was. Right? The evidence speaks for itself, ladies and gentlemen. Evidence speaks for itself. So then he says it's about a quarter mile to the next stop. So if he's going 65 and my client's doing 65, he even admitted to you, Metter admitted to you, that my client would have been long through that next life before Officer Metter even hit it at a quarter month. He was not doing 65, ladies and gentlemen. In fact, we don't know how fast he was going. Why don't we know how fast he was going? Because Metter didn't try to put a radar on him. Didn't try to do anything except pull out and say, I'm gonna go stop this guy. And then when he gets up there, here's where the state wants you to say, oh, this is a problem. This is a reasonable cause or a probable cause for the stop. He runs his plate and finds out the registration was expired. Okay, I asked Metter specifically, is expired registration indicative of intoxicated driving? Of course not, right? It's a fix-it ticket. That's what you get. You gotta get registration, pay the ticket, case gets dismissed. So, and I asked him, but for the fact that you perceive my client to be speeding, would you ever run his plate? He said no. Why? Because he was going the opposite direction. He was going northbound, client was going eastbound. What's that? How to do the never eat soggy Wheaties? Yeah. So client was going westbound, complete opposite direction. So, but for Metter thinking that he was speeding, he would never pull up behind him. He never pulled up behind him. He would never run his plates. He never run his plates. He would never have seen the registration was expired, and therefore my client would never have been pulled over. Let's talk about the investigation itself. When he pulls into the gas station, Metter realizes Mr. Gomez doesn't speak English very well, so he calls for a Spanish-speaking officer. Ruiz shows up. Ruiz starts talking to him. And Ruiz told you that he didn't translate everything verbatim. He paraphrased it, is how he put it. Metter testified that there were inconsistencies in my client's statement, which led him to believe that he maybe didn't have the mental use of his faculties due to intoxication, right? But there were no inconsistencies. Well, you heard Ruiz talk about coming out from Cleveland, helping the client move. Ruiz didn't translate that all. All he said was he came from Cleveland and he helped a friend. Right? Then later on, he says again, he helped a friend move. And then Ruiz says that. And then Metter tells you, well, that's an inconsistent statement. He told you he came down to get gas. He was coming from his house to go get gas because gas is cheaper on the side of town. Right? That's what that's what the client said. Right? And Ruiz said that. Officer Metter says, oh no, that's an inconsistent statement. He never said anything about getting gas before. He said he had come down, helped a friend move. He said that the first time, and he said it the second time. And then they asked him, well, where is he going? He said he was coming down here to get gas because it's cheaper. Right? So he came to get gas because it's cheaper in that thing. Then Metter goes on to talk about, oh, I pass all these gas stations. Well, we all know there's gas stations everywhere. Every single gas station has a different price. I know I've got my favorite one I always go to, and I will pass a dozen other stations to get to that one to get the cheapest price on gas, especially nowadays, and especially coming into the summer months. We all know that. So everything that Metter told you or used in the totality of circumstances is perfectly reasonable. Now let's talk about the field sobriety tests. They want you to start right here, like this. Right? I'm struggling to do that. And I have perfectly good balance. You start here, and then you've got to do heel to toe for 9 steps, and then a series of small turns. I know the SFSTs inside and out. I was a prosecutor, I was a police officer, a prosecutor, and now a defense attorney. I've done these thousands of times. I've seen them thousands of times. All right? So I can do them. My client got one time on the instructions. Matter claims he took 8 steps instead of 9. Okay, maybe he miscounted. All right. And then a series of small turns. They expect somebody to do this to turn around. All right? That's not a natural movement. Everybody, when you turn around, when you're just thinking, I got to turn around and go back, you get to the end, you turn around, and you go back. No falling over, no stumbling, nothing. Just an unreasonable test that is perfectly unnatural for a human body to perform. And he claims that the National Highway Safety and Transportation Committee established these so that it would be difficult. Sure, maybe that's the case. But even a sober person, I believe he even said, somebody, what were his exact words? It was relatively easy for somebody who is not intoxicated. Not completely easy, not perfectly easy, not easy at all. Right? Relatively easy for somebody who's not intoxicated. So the field sobriety test, useless. Absolutely useless. And then he talked about, him and Ruiz both said, there's a strong odor of alcohol on his breath. Right? But then I asked, if you have 1, maybe 2 beers and have a strong odor of alcohol on your breath. Yes. I asked later, if you have 2 beers, are you intoxicated? No. And then we get to Varner, and Varner says it was a moderate to mild odor of alcohol on his breath. Which one's the truth? We don't know. We weren't there. But that's completely unreliable as well, because there's inconsistent statements. If Better wants to use the inconsistent statements, that's an inconsistent statement amongst the state. These are the people that work for the prosecutors. This is their job. Their job is to find people guilty, for the state, not the prosecution. Their job is to look for things to find people guilty. Right? That's what they try to do. So they're going to say what they want to say to get to that point. Now, as far as the jury instruction, there's a section in the jury instructions that says you are to disregard evidence if unlawfully obtained. Page, I believe it's 5. 1, 2, 3, 4, 5. Page 5. An entire section talks about evidence unlawfully obtained. I've already explained this to you, but I'm going to go over it again. The matter says he knows that intersection. Based on the flow of traffic, he believed my client was speeding. There was no traffic. He couldn't go after him. He couldn't tell how fast he was going. Then he goes out after him. A quarter mile later, he catches up to him and runs his plate. That is, without him thinking that my client was speeding, he would never run that plate. That's unlawfully obtained evidence. He just looked for something to find.
Objection, Your Honor. May we approach?
Why just lose it? I said, like, why are you going after me?
Or so. Okay, at the end of it. Right, and so. So you can as well. All right, come on. Okay, 3 minutes.
So, again, speeding goes in behind, runs plate. That tells you here down at the bottom and or expired registration, right? What I'm asking you to think of is, why did he find out that registration is expired? What led him to that? But for him proceeding a speeding, he would have never run that plate. And if you find that probable cause did not exist, or as well as you don't believe that he lost his mental faculties, we didn't see him fumbling, we didn't see him walk, urinating himself, we didn't see him everything. During jury selection, I think somebody said that. You know, they urinate themselves, right? They stumble, they act a fool, they're belligerent, things like that. We didn't see any of that. What we saw were those unnatural field sobriety tests that are designed for people to fail. That's what we saw. Nothing else. No other driving facts. So no loss of mental faculties, no loss of physical faculties. And then they say at the time that he blew, his alcohol was 0.153, but nobody can tell you what it was at the time he was driving. The law is driving while intoxicated, not intoxicated when you blow into the machine. Driving while intoxicated, which means they have to prove beyond a reasonable doubt that at the time he was driving, he either lost his mental faculties, lost his physical faculties, or was it 0.08 or higher. They have proven absolutely none of that. So ladies and gentlemen, the jury, you have one verdict and one verdict only. It's at the very top right there for you. We, the jury, find the defendant, Fugitive of Santa Maria, not guilty. Thank you very much for your time.
Okay, thank you. All right, State.
Thank you, Judge. Judge, may I publish a PowerPoint for the jury? May I publish a PowerPoint for the jury?
Sure. Say I haven't seen
All right. Defense said a lot of things. Some of it confusing. Some of it, right? Let's start with the jury questions. This piece he pointed out to you said disregard evidence if unlawfully obtained. There's a piece I want to circle here. It does not say that you must all agree the state has proven beyond a reasonable doubt that Officer Michael Metter reasonably believed that the defendant was speeding. It says was speeding and or had expired registration. There's no reason hard. The officer thought he was speeding. He goes to the line, the officer sees him, he follows him, he tracks him, he pays him. Was it perfect? No. But he gets up to the line and he runs his registration. He finds that his registration is expired. That's all he needs. That's it, right there. That's what the jury instruction says. It says or. If you find that he had expired registration, it doesn't matter. Look at all the evidence. Now, let's go through this and let's make it easy. That's all the replay. Every single person, except for the last videos, said that this occurred on October 6, 2024. That's an easy one. Let's cross that one off. The officers both said it was in Harris County, Texas, and in a public place. We know that it was this defendant. How do we know that? Because the officer said it was. Because the officer said, I was going down the road, I saw this car, I pulled him over, and he was the one behind the wheel, and you see him on the video. Let's cross off another one. Operated a motor vehicle. How do we know that? You saw it on the video. The officer told you everything you need to know. It's not hard. In a public place. You see on the video, he's at a gas station. The officer tells you he's at a gas station. And he's operating a vehicle on a public roadway. Straight from the officer. It's not hard. None of those are hard. And fairly risky. Then we get to while intoxicated. This is still easy. Why is it easy? How do we know he was intoxicated? Because I have this piece of paper that says subject name, that has the operator that you heard from, his signature on it. And it says what his DNC was when he blew. Now, this is important. What does it say? Let's use the low one, 0.153. This is a smaller detail that you may not have caught, but you have to use your memory, think back. When the officer was telling you about the HGN, you remember there was a small part at the end of the HGN where he said, onset, he was talking about the onset prior to 45. And it's what the officers used to calculate about where the defendant is on the scale. He told you what he thought the defendant was at that point in time was what? It was around 0.15. And then he went and got a breath test and he confirmed it. So it goes. It doesn't have to be hard evidence. Remember yesterday we were talking during jury selection and I brought up Stonehenge and I said, and I told you, you might not have the full picture. But you don't need the full picture. When you get enough pieces together in a puzzle, you know what the picture is. And that's all this is here. We have all the pieces we need. Only thing left for you to do. So go back in the jury room, take a form, and return a guilty verdict. That's what I'm asking you to do right now.
All right, thank you. All right, ladies and gentlemen of the jury, it's now time for you to deliberate. Get you going, do you mind escorting them to the jury room?
Okay, all right, so good luck. Judge.
Okay, we're in recess. I just want to remind him not to put the alternate in the room with them. That's what I was saying.
What was that?
Not to put the alternate,
Oh, okay.
because I always.
Then you gotta go take that stick.
Oh, right.
2, 3, 4.
Hey, come on. Oh, wait. Yeah.
We have states 1 through 4 and defense 1, right?
Oh, that's what.
Did you come back tomorrow? Did she see the back on the tomorrow? What is what?
It's this judge signed a meeting from bail around me.
No. We already told her she can come back, Victoria told her, yeah, the 22nd of next year. No, she don't come back. No. So, yeah, I talked to her. Oh, I thought he was talking about the.
No, I'm
Okay.
Parks. Probably Parks.
He was hollering. Your Parks? Yeah, she gotta come back tomorrow.
Okay, you signed the bill around, I'm gonna have to.
Yeah, I'm saying, he did not resolve it, she finally cleaned it up.
Okay.
He probably supervision for the follower problems too.
Yeah, signs.
Jen signed it.
Oh, nice.
Yes. Thank you. He was, the thing that we was awesome, and we all knew it was awesome. Because he was joined.
What was it?
Still Stevens.
Federal or
No,
state?
state, the two lead. But that good, starting.
No, I think they last had for PhD. Gerald, Jerry Montcalm. Yeah.
In case the jury expands.
Yeah.
I mean, test. You don't want to hear.
Oh, I see what you're saying.
I hate to be wonders. Yeah, just fuck, I did that. Well, that makes me feel bad.
Well, you don't feel great, because everybody thinks so.
I appreciate that.
Yeah, I didn't see them all there. But they always take care. A lot of juries, like some area county, there's like, screw this, let's get out of here. Now I'm getting to you. So that's good. Thank you. They were both 10. So the one weeks, I don't know, yeah, we started from jury thing, was all one, so we just did all. Then I was nothing, some people that write trials where it was their strong state cases, you don't very minute not to get out of the Friday at 4 o'clock. Would you agree, Greg?
What's that?
I said, I think the jury's going, like, they seem like they're very fair, like both sides of the court. They seem like they care.
Yeah.
So we're trying to be very wise. Yeah, so that's good.
Yeah.
And that's all you're gonna finish. Yes, just make sure. If you're not using, yeah. But. Yeah. Who was the DA at the time? Your previous. Come on. Show that department. Yeah. I think like we put that button in something. It's the right. No, I mean, yeah, it's I only imagine. We're playing a game. They'll see. Fuck.
What time do you leave? You leave at 5 or 4?
4:30. I never. I think. Oh, yes. But the way I look at it is.
Your contributions all.
Right.
But over, yeah, while you're in civil defense.
You know, from. So I said, I just done it up over here, so, okay.
Yeah.
So
I didn't think it's trying to change my, yeah, I don't want to stay with you. What is that? I'm better, I'm like. Yeah. Thank you. That's true, that's true. Because why I had to think of it. That's a different. Soon as I got here, this is like a set up like started. I think that's it. And so you never need to. Always going to go all the back. I knew I stuck something. I didn't do it. I couldn't do it. I need to forget that. It's the programs you're doing. I think if you talk to my medicine out there, I'm like, how do you see this? You're sending it out. But I don't speak as station case.
He's in custody, he ain't getting him. He's bonded out first before he pays his trial. I never tried. I would never want to try things that this should be. Was he actually prior to 10 years? Why? And just dropped to a PCS on track of regards. Why move your record? Yeah, and they did it. So I was like, hey, whatever. That's a harder thing, another thing to do with trauma. You don't need to feel that. And only that's. Yeah.
She would assign a failure and a single soul and a emotion disposed. Their children are duplicates and one of them are parks. But acceptable.
Yeah.
Could you install?
Oh, right.
Yeah. Very good.
So on parks, is there anything else?
Parks, there's a king, there's a note under it, the motion is well. Yeah.
Got it.
And also days.
And what else?
The jail release instructions for Ramirez, I pushed those through too soon, but we didn't have her come up today, we had to reset for tomorrow. Do you want us to do that tomorrow, so we have a PR going on?
Yeah, I guess so. Unsign it?
Yeah.
Appeal for your resources.
Of course.
It's like the last note, very frustrating.
Want the exhibits.
Question? Verdict.
I'm assuming there's one.
Think it's a question?
Yeah, one question.
Yeah, but they always hit just one. They never did two. Mm.
You got a question?
Question?
Or we heard a ding. I don't know.
Hey, you guys? You guys?
Let me just see what they, if it's a question.
Okay, yeah.
Give me one second. I just want to keep on.
We're still on?
Yes. Okay, I think it did it right.
Yes.
Verdict. Hey, we have a verdict. Ramona. Let me go get Ramona.
Ramona states any and not a, could you prepare to file a stipulation of evidence?
For the project, yes.
Yes, because we always need those before they get leaving.
Do we need it?
It just in case it's.
No, but I think we can just stipulate on, right?
No, we need to look at signature and the signature and everything for the judgment.
Oh, that part.
Yeah, let me get him in first to sit.
Yeah. Okay. I thought you were talking about first of all.
No.
Okay, you ready? Okay.
Yeah.
Oh, where's Tony?
No. Oh, wait, we need it.
Yeah, he went to go get him.
Pero no digas nada, no, yo les paso la. No sé qué, pues un bisón. Cada vez que me viene este pues. No puedo venir. All right, for the jury.
Okay. Ladies and gentlemen of the jury, have you reached a verdict? Is it unanimous? Okay. I'm now going to read to you in the state of Texas, cause number 2532700, the state of Texas versus Odir Alberto Gamez Santa Maria. We, the jury, find the defendant guilty of Class A driving while intoxicated as charged in the information. Okay, you've been found guilty. You may take a seat for a moment. Does anybody who would like the jury polled?
Yes, Your Honor.
Okay. ladies and gentlemen of the jury, is this your verdict, man? Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Your verdict?
Yes.
Your verdict, okay.
Thank you.
All right, sir. Just give me a second. Ladies and gentlemen of the jury, you have concluded your service. I thank you for everything that you've done. It's really an invaluable service. You may now retire to the jury room. If you give me a couple minutes, I'll come back there and talk to you, and then we'll try to get you all the things that you may need to get you out of here. Yeah. Thank you.
All right, for the jury.
Please be seated. Mr. Gomez, I want you to understand that you do have the right to appeal this verdict. If you decide to do that, there are certain timing requirements that must be fulfilled and documents filed. I can let your attorney explain as much as he knows, if that's something that you want to do, but timing is of the essence if you want to appeal this, but you do have that right. We do have to sentence. And if I'm correct, parties, you have agreed to a sentence.
Yes, Your Honor.
Okay, and the agreement is?
210 days.
With credit for the 73 days. Okay. I'm now going to sentence you to 200 days in jail. I will give you credit for 73 days that you have done. Mr. Gomez, you need to understand that this will now reflect as a conviction on your record. This now makes 2. If you ever pick up another DWI, you will be charged with a felony offense, and you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. I would never, even if you've had a sip of alcohol, get into a car and drive because you're taking a huge risk. Do you understand? Okay, so you may be seated, and I think that.
Are we going to keep it as a second with a class A?
Yeah.
1.5?
Yeah.
So you're making sure, okay.
Yes. Well, they found it. Yes.
No, they found the 0.15 true. The second is an enhancement, which would need to be found true as well.
I thought we were simulating.
Yes, we'll stipulate to the first.
Okay.
Doesn't change anything?
Right, okay, so we need him to sign documents, so just don't send him down until the documents are ready to be signed. I'm gonna suspend the license for a year, okay? Do not drive until you get a license. Otherwise, you'll be right back in custody.
Just for the record, Judge, although I've admonished him, well, the court admonished him that this could have negative effects on his immigration status.
Right, okay, yes, that's in fact true, right. You being found guilty of this DWI offense, this can and probably will impact any kind of immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You have an ICE hold now, so you know now that there are immigration consequences for future purposes. When you're on bond, don't violate, there are severe consequences, as you now know. Anything else you'd like?
No, Your Honor.
State?
Doesn't really say how.
No fines. Yeah, no fines, nothing else, just, I'll waive any kind of surcharges that would be imposed by the Department of Public Safety. Right, so if you don't mind, give me the motion and then I'll sign it for you.
Thank you, Your Honor.
Okay, all right, so just hang tight, but don't send them down just yet. Okay, all right, let me go talk to them real quick and then I'll let you guys go talk to them as well. We are done.